on the screen.
I'm content. Oh, there we go. I'm content with it just being on the screen. That's fine by me.
Yes, Your Honor. All of my team members, we are in our school right now, and school is currently in session. So there might be a couple times when the bell interrupts us, or you might hear something going past our door, which is next to us. So if you could just have some patience with us, we would appreciate that, because we're in the middle of school right now.
Thanks for the heads up. That'll be fine.
And finally, before trial begins, can I make appearances for the court and introduce my team?
Yes, please.
Thank you, Your Honor. So my name is Julia Peter. I am the opening attorney for you today. I go by she, her pronouns. My co-counsel is Eliza Sullivan. She will be closing for you today. She also goes by she, her pronouns.
Good afternoon, Your Honors.
Yeah.
I will be directing Hollis Fitzpatrick, played by Elliot Burbrick, who goes by he, him pronouns.
Good afternoon, Your Honors.
And Ms. Sullivan will be directing Phoenix Anderson, played by Shershong Moore, who goes by he, him pronouns.
Good afternoon, Your Honors.
And finally, our bailiff is Alex Sanger, who goes by he, him pronouns.
Good afternoon.
And that concludes our pretrial matters. Thank you.
Thank you. And for the respondent, anything for us today?
Yes, Your Honor. Firstly, may I make appearances for my team?
Please.
So my name is Manan Bitch, and I will be your opening attorney. Alongside myself, Rohan Nambiar is my co-counsel, and we will be representing the respondent, and Rohan Nambiar will be the closing attorney. We will be calling two witnesses today, played by Kaya Park as Dr. Ellis Mazakis and Timothy Jordan as Aspen Bennett. Secondly, we would like to remind the court that according to Rule 901, all exhibits and witness statements contained in the case materials have already been stipulated as admitted.
Thank you.
I believe the opposing counsel has already asked for permission to record, but I think we would like to ask for verbal confirmation as well, if we may record.
That would be fine with us.
No further pretrial matters, Your Honor.
Well, thank you very much, everybody. All right, I think I have got a little statement to read to you here. Let's see if I can get this on my screen. Oh, I spoke too soon. Maybe I don't have a little statement. Hold on one second. Here we go. Before we begin the trial, I have a brief message to share with today's participants. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they're called implicit biases or unconscious biases. As participants in the Ohio mock trial program, it is important to resist jumping to conclusions or acting upon personal likes or dislikes. Resist letting bias, prejudice, public opinion influence your behavior inside or outside of the courtroom. Treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Have the witnesses all been sworn in? Okay,
No,
if you
Your
could take
Honor.
care of that now, please.
Will all witnesses and parties who are to give testimony in these proceedings, please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, and your testimony will comply with the rules of the Ohio mock trial competition?
Yes. Yes.
Thank you, everyone. Is the relator ready for opening statements?
Yes, we are, Your Honor.
Please proceed.
Thank you, Your Honor. Your Honors, opposing counsel, may it please the court. On March 15th, 2020, the government shut down businesses in response to COVID-19. Following this, unprecedented regulations on occupancy, floor plans, and hours of operation burdened small, family-owned businesses like Fitzpatrick's. These business owners were forced to bear more than their fair share of the COVID-19 pandemic's burden, and in the end, these restrictions closed Fitzpatrick's. Your Honors, constitutional protections do not pause for a pandemic. Constitutional protections never pause. The 5th and 14th Amendments provide for just compensation when private property is taken for public use. The language taken, however, requires some elaboration. The courts have decided, in cases like Armstrong, that property is taken by the government when onerous regulations place a should-be public burden on a select few. the extreme COVID-19 regulations disproportionately burdened Fitzpatrick's, and therefore a partial regulatory taking has occurred. In order to demonstrate these things, the relator will show that the three factors set forth in Penn Central v. New York tip in our client's favor because 1, the regulations had an adverse economic impact on Fitzpatrick's. 2, regulations interfered with Fitzpatrick's investment-backed expectations. And 3, the regulations were implemented without an exemption process and without a commitment to communication. To demonstrate these things, we will call 2 witnesses today. First, we will call former restaurant owner Hollis Fitzpatrick. Mr. Fitzpatrick will tell the court that his restaurant was a dine-in establishment for over 40 years, and that he invested in it with the expectation that it would remain such. He will also tell the court that through those 40 years, the government has never regulated occupancy, floor plans, or hours of operation. Next, we will call Phoenix Anderson, the licensed accountant for Fitzpatrick's. Mr. Anderson will confirm that Fitzpatrick's was profitable prior to COVID-19. He will inform your honors that from a financial perspective, regulations diminished investment benefits and prevented Fitzpatrick's from breaking even, let alone making a profit. The respondent will also call 2 witnesses today, Ellis Mazakis and Aspen Bennett. Ellis Mazakis, the director of Buckeye's Department of Health, will show how the department overreached in their handling of the pandemic, excessively burdened small businesses, and delayed providing any support for those businesses. Aspen Bennett is a former employee of Fitzpatrick's, disgruntled due to stealing accusations and frustrated from what they believe to be bad business practices. Aspen Bennett was not privy to Fitzpatrick's behind the scenes. Your honors, constitutional protections do not pause for a pandemic. The COVID-19 regulations were an attempt by the government to protect the public, but the devastation caused by these regulations constitutes a partial regulatory taking. The public benefit outweighs the burden on the claimant outweighs any public benefit. It is for these reasons that we ask you rule in favor of the relator and initiate property appropriation proceedings. Thank you.
Thank you very much. And to the respondent, are you ready with an opening statement?
Yes, Your Honor. May I proceed?
Yes, please.
Yep. May it please the court. Ms. Patrick said Fitzpatrick's bared more than their fair share in the pandemic. However, all restaurants experience the same situation. In fact, a search for a scapegoat is the easiest of all expeditions, and blaming others is easier than accepting one's own. A example of this phenomenon in former Harmony business owner Hollis Fitzpatrick. On April 12th, 2021, Fitzpatrick, a restaurant owner, found his scapegoat for his already failing business. When public health measures put in place by the state of Buckeye for the protection of its citizens conveniently aligned with Fitzpatrick's decision to close their restaurant, Fitzpatrick decided to jump on this opportunity to scapegoat the government for the failing business model. In early 2020, COVID-19 forced public safety to be the top priority of the state. Governor DeBeer ordered numerous businesses deemed as virus hotspots, which included restaurants, to be temporarily closed from March 15th to May 15th, 2020. These restrictions increased the clearance between tables to at least 6 feet, installed physical barriers to prevent close contact, and asked all customers and staff to wear masks. However, due to Fitzpatrick's financial struggles, Fitzpatrick decided that these public health measures were not to his personal liking. Fitzpatrick utilized these inopportune times to his advantage when he made the state of Buckeye his scapegoat, and regulations and restrictions that restaurant by labeling the government's actions as on behalf of Fitzpatrick's bears the burden of proof in this case. Yet it is clear from the evidence that this case weighs in the favor of the respondent. Firstly, the regulations did not destroy Fitzpatrick's investment-backed expectations or financial commitments. Under Concrete Pipe and Products of California versus Construction Laborers Pension Trust for Southern California, if a property owner operates in a highly regulated industry, the owner cannot base a constitutional taking claim on additional regulations put in place after the purchase of the property. Since the restaurant industry is such an industry, and the regulations were put in place after the purchase of the property, the first factor weighs in our favor. Secondly, the state of Buckeye did not single out Fitzpatrick's restaurant with its COVID-19 regulations because under Penn Central and Dover City versus Acre Farms, the restaurant was not impermissibly singled out and the regulations serve to prevent harm to public safety and public health. Clearly, both factors weigh in favor of the state. While the respondent bears no burden of proof, the state's witnesses will conclusively show that the relator cannot sustain their burden. The state will first call Dr. Ellis Mazakis, the Buckeye Director of Health and Human Services, and a medical doctor with expertise in infectious diseases, health services, and public health. Through their expertise, she will testify that the reasonable regulations put in place were in the public's best interest and served a harm-preventing purpose. The state will secondly call Aspen Bennett, a former servant at Fitzpatrick's when Fitzpatrick's went under. Mr. Bennett will testify to Fitzpatrick's unsanitary conditions, Fitzpatrick's rigid response to the pandemic, as well as the harm-preventing regulations. In sum, there has been no partial regulatory taking here, only a mismanaged business desperately trying to play the blame game at the government. In fact, Fitzpatrick's already tried and failed to prove that the restrictions were physical per se or total regulatory taking. And now with only one option left, Fitzpatrick's partial regulatory claim is unsupportable beyond doubt. For the foregoing reasons, the state respectfully requests that the court dismiss Fitzpatrick's claims with prejudice. Thank you.
Thank you, Counselor. Are we ready to call witnesses?
Yes, we are, Your Honor.
All right, the relator may begin, please.
The relator calls Hollis Fitzpatrick to the stand. I'm going to be asking you some questions on behalf of the
I'm well. How are
relator.
you?
How are you spelling the last for the court?
Hollis Fitzpatrick,
What's your current occupation, if you have any?
Fitzpatrick. Currently, I am not employed. As of late, I was the owner of Fitzpatrick's restaurant, which unfortunately we had to close down recently.
How did you come to own Fitzpatrick's?
It's a family business. I inherited it after my parents retired.
When you took over Fitzpatrick's, what were your intentions with the restaurant?
Well, my partner being the main moneymaker of my family, I wasn't really looking at Fitzpatrick's as a huge need for income. I just had such great memories growing up there when my grandparents and my parents ran the restaurant. I wanted to preserve that Fitzpatrick's legacy and have something to pass down on to the next generation.
Before COVID-19, did you reinvest into your restaurant at all?
Yes, I did. Made some pretty fun investments. We installed a self-serve ice cream bar, some pinball machines that gave the restaurant a fun retro feel.
Were you able to use these investments?
No, eventually, when our restaurant had to go through some restrictions, we weren't allowed to use our self-serve ice cream bar at all, and our pinball machines were restricted in
Has
terms of amount
Fitzpatrick's
of
ever
use.
struggled financially before?
Yes, and most so during the COVID-19 pandemic.
What happened with COVID-19?
Well, in the beginning, our restaurant was forced to close down by the government.
Has the government ever shut down your business before?
No,
Your Honor.
Sorry, was that an objection?
Yes.
Please
The
proceed.
leading question.
Please, I can't see who's making the objection. Can you turn your screen on?
My camera on, Your Honor. Can you see me?
Let's have a look here. We'll try gallery view. There you are. Okay, sorry about that. Sorry for the technical glitch. Yes, please
Objection was
proceed with the objection.
It was a leading question, Your Honor.
Any response?
Yes, Your Honor. I did not imply an answer with my question. I asked before, and I did not imply that the answer was yes or no within my question, and therefore it's not a leading question.
Objection overruled.
Thank you, Your Honor. May I re-ask the question?
Yes, please.
Mr. Fitzpatrick, has the government ever shut down your business before?
no, it is not.
How did this shutdown affect the restaurant's finances?
Well, Fitzpatrick's has always been a sit-down, dine-in restaurant. This shutdown prevented any customers from coming inside of our building, and we weren't able to turn a profit.
Did you try to work around this issue?
Of course we did. We tried a lot of stuff with takeout because of the more professional subscription services for online takeout orders were simply too expensive for our restaurant to afford. We decided to make a website. And when that website generated errors and didn't work out, we had to settle on telephone orders.
Were these telephone orders profitable?
No, not at all.
Were restaurants ever able to reopen?
Yes, about 2 months later, the governor reopened the restaurant.
Did you expect it to be 2 months later?
No, in fact, in the beginning, the governor had told us that the order would lift a month earlier, but that didn't happen.
What were the stipulations to opening dining up?
Well, there were several restrictions. We had to keep customers 6 feet apart. We were operating at half of our usual capacity. We had to keep plexiglass between all of our seating.
Was there any outdoor seating available?
No, we reopened to indoor dining on the 21st, but a full week earlier, restaurants with outdoor dining capabilities were allowed to reopen. Unfortunately, Fitzpatrick's is bordered by it, so we weren't able to put any customers outside.
Let's go back to that 6-foot distance regulation that you mentioned earlier for indoor dining. Would you recognize a
I
diagram
would.
of your restaurant? Let the record reflect that I'm screen sharing what has been previously entered into evidence as Exhibit D, diagram of Fitzpatrick's. Opposing counsel, is this clean and unmarked?
Yes, Your Honor.
Mr. Fitzpatrick, could you explain what you're saying with this 6-foot distance regulation using the diagram?
Yes, so you can see where the seating is crossed out. This is where we could not seat customers because we had to keep 6 feet between them. We had to keep 6 feet between tables, and we had to keep an empty table between all of our tables.
Did you try to work around or with?
Restaurant Association and Buckeye optimization computer program to help figure out what are best the restrictions.
How many 16
16.
individuals had walked into your restaurant? Would you have been able to seat all of
That
them?
would be great, but unfortunately, no. If we had to keep 6 feet between each party, so only if the perfect number of people in each party came to our restaurant could we fill all of our seats.
So how many individuals could you seat?
A grand total of 7,
Pre-COVID, how many seats were available?
34.
Were there any other regulations besides the distance restriction?
Yes, there was a mask mandate, which some customers grumbled about, but most importantly, there was a curfew.
How did this curfew affect the
Well,
restaurant?
under usual circumstances, Fitzpatrick's thrives off of its dinner rush. We start to get busy around 5:30, and until we close at 8 o'clock, we can turn tables 2 to 3 times over. But this curfew closed our restaurant at 6 o'clock, completely destroying our dinner
Has
rush.
the government ever made you close your restaurant at 6 o'clock before?
No,
Has the government ever mandated that you seat 6 feet between parties
No.
before? How many months were you open with these indoor restrictions?
well, after we reopened in May, about 7 months with the restrictions.
Did you expect to be open with indoor regulations for so long?
No, like I said, I thought we'd be open back up when, like the governor said at the beginning of all this.
Was there any way to receive an exemption to these regulations?
Initially, I wasn't sure, so I actually reached out to the health department and asked them myself. And they eventually got back to me and said that such a process didn't even exist.
How much time went between your inquiry with the government and their response?
Almost a month.
Did they eventually create an exemption process?
Yes, they finally did.
How long after closing restaurants down did they create this exemption process?
What was the beginning of November? So about 8 months.
Did you apply for an exemption at this point?
Yes, of course I did.
Did you receive an exemption?
No, actually, they sent me a letter with an inconclusive reply requesting more information before they made a final decision.
Would you recognize a copy of this letter?
Yes, I would.
Let the record reflect that I'm G.
Yeah.
Opposing counsel, is this much time went between your application and this letter?
Over a month. And by that time,
Was a month significant for your restaurant?
yes, at this point, we were hanging on by a thread. Every second counted, and it was just too late.
Thank you, Your Honor. No further questions.
Thank you. Are you ready to cross?
Yes, Your Honor.
Please proceed.
Good afternoon, Mr. Fitzpatrick.
Good afternoon.
So before the pandemic, your profit margins were already pretty slim, weren't they?
We always had sort of slim profit margins. I wasn't really running Fitzpatrick's for huge profits. It wasn't a source of livelihood. I just wanted enough to keep the business going and preserve my family's legacy so I could one day pass it down to the next
And
generation.
for similar reasons, you kept prices pretty low.
Yeah, I mean, that's always been my family's tradition. I had no intention of changing that. I mean, that would change the Fitzpatrick's business model and what Fitzpatrick's is as a restaurant. And I didn't want to do that.
And in 2010, you filed for Chapter 11 bankruptcy, correct?
Objection, Your Honor, more prejudicial than probative. May I be heard?
Yes.
This attempted filing for bankruptcy happened 10 years ago, and it was not a successful filing for bankruptcy. And therefore, the probative value of this question is substantially outweighed by its prejudicial value. And I ask that the opposing counsel's question be stricken from the record.
Any response?
Yes, Your Honor. The financial situation of the restaurant is continuous, and its financial situation 10 years ago does have a bearing on its financial situation today. Additionally, this goes to show Fitzpatrick's skill as a business person, because they did indeed file for Chapter 11 bankruptcy 10 years ago.
Objection overruled.
Would you like me to restate the question?
You may.
You filed for Chapter 11 bankruptcy in 2010.
Yes, in the aftermath of the Great Recession was a really difficult financial time for a lot of people. And so to get back on our feet, we attempted to file to help reorganize our assets. Although we missed the filing deadline, so it was not successful filing bankruptcy.
And in 2019, you made some investments in your restaurant, correct?
Yes, we were able to push through that difficult time of the Great Recession. That next decade, we were turning some pretty good profits, so we reinvested back into our business. We got an ice cream bar, some pinball machines, a projector, and a new point of sale system for the restaurant.
Right, and around your restaurant, you love to do like DIY projects, right? When things broke.
Yes, yeah, I'm a big fan of this old house, and I think I kind of think of myself my own Bob Villa. So when those contractors that you can bring in to do those sort of projects, how much they charge just to address a problem, much less fix it, I saved a lot of money, and I felt like that was a good investment as a business person to do those projects myself.
Mr. Fitzpatrick, could I please ask you to confine your answer to yes or no from now on? So these DIY projects included redoing the plumbing in your restaurant, correct?
Yes, like I said, hiring a professional to do that was simply absurdly expensive.
And you received a health code citation from the Harmony Health Department for this?
Objection, Your Honor, more prejudicial than probative. May I be heard?
Yes.
This line of questioning is substantially prejudicial since it's going into health citations that Mr. Fitzpatrick received for his restaurant. If opposing counsel's goal of this line of questioning is to address the regulatory nature of the restaurant industry, opposing counsel can merely ask generals and not address specifics for my
Have
witness.
you any response?
Yes, Your Honor, that is not my goal. If Fitzpatrick's does have a history of health code citations, that would mean that customers would tend to turn away in the midst of global pandemic when they're especially concerned about safety. So that is the point I'm trying to make.
Objection overruled.
Would you recognize a copy of these health code citations if issued?
I would, yes.
Your Honor, let the record reflect that I am screen sharing a clean and unmarked copy of Exhibit A. So Mr. Fitzpatrick, if you would follow along with me in the bottom right-hand corner. All 12 violations are willful, which is the most severe of the 4 types of violation designations. A willful violation is defined as a violation in which the employer either knowingly failed to comply with the legal requirement or acted with plain indifference to employee safety. Did I read that correctly? Yes,
You did. I personally believe that my restaurant was a safe and a clean establishment. Unfortunately, I was not able to bring my projects 100% up to the state's code, so they issued citations. But I can assure you that Fitzpatrick's is a clean and safe establishment. Once again, I would ask you to confine your answers to yes or no, please. And now moving on to part 4. If you would follow along with me in the bottom right-hand corner. Plumbing pipes created overflow and draining dirty water into the sink where produce and salad are prepped, which could cause an unsanitary environment. Did I read that correctly? Yes, you did. Okay. Moving on from the exhibit, you said direct that you had, sorry, never mind. You were allowed to open for delivery in the middle of the pandemic, correct? Well, since we shut down, yes, delivery was an option. And as I testified earlier, we walked through many options or many attempts for us to use that delivery service. And unfortunately, when we exhausted all of our online options, we had to go to those telephone orders, which didn't work out because it seems like people don't just want to pick up the phone and call anyone anymore. It has to be a website for it. And you didn't try door delivery programs like Ultra Eats or Door Delivery? No, like I said, those were too expensive. The restaurants that had that infrastructure in place before this were very lucky. Fitzpatrick's wasn't able to invest in anything like that. But you did receive over $250,000 in paycheck protection grants from the government, correct? Yes, and we used this to keep our restaurant alive during the pandemic, which even that wasn't enough to help combat the restrictions. And yes or no, these paycheck protection grants were intended for you to keep all employees on staff? That was the stipulation with the loan. If the employees were not kept on staff, you have to assume the debt. Unfortunately, we found ourselves in the financial situation where it's actually a better choice for us to lay off employees and assume the debt than to continue in the same situation we were.
Mr. Fitzpatrick, your annual profit margins were about 3.5%.
Sorry, could you repeat that?
Annual profit margins were about 3.5%.
Prior to the pandemic.
Yes. Your annual revenue, your annual sales were about $500,000.
That sounds about right.
So that means your annual profit's about $17,500.
Objection, Your Honor, lack of personal knowledge. May I be heard?
You may.
While Mr. Fitzpatrick is the owner of the restaurant Fitzpatrick's, he employs Phoenix Anderson, who is the accountant for Fitzpatrick's, and Mr. Anderson will have the knowledge to comment on all the specifics of these monetary values. And therefore, I ask opposing counsel not question my witness about the specifics of these financial situations, since my witness doesn't have the personal knowledge to comment on these things.
Any response?
Yes, Your Honor. Mr. Fitzpatrick was aware of their profit margin and their annual sales, so I don't see why he can't extrapolate from that the annual profits.
May I respond?
Oh, yes, you may.
Again, this would be more suited for the accountant, since I'm not sure it's possible for Mr. Fitzpatrick to do quick math on the stand, and I don't think that's an appropriate thing to expect from my witness.
I'll overrule and let him answer.
So you would agree that your annual profit margins, your annual profits were about $17,000.
I don't have a calculator with me. I mean, that sounds about right. You can ask Phoenix if you want the more specifics. I can give you a rough idea. That sounds in the ballpark.
And the government granted you $250,000 in loans,
Yes.
which is an order of magnitude greater than your annual profit.
Sorry, can you repeat that?
And that's like an order of magnitude greater than your annual profit, right?
Yes, but you have to realize during the pandemic, we were losing money because of these restrictions. Those were hit by this pandemic, right, increase in customers and owning and building expenses of the restaurant with no profits. We were losing money, and these loans from the government was not enough to keep
Plus,
us
the
alive.
government did loan you more than 14 times your annual profit, and yet you still blame the government for your restaurant going under, correct?
I don't know what to tell you, counsel. We used that money to keep our restaurant alive, but because of what we were losing, it's not enough to sustain our restaurant.
All right, and you don't blame the high school student who built you a non-functioning website for your restaurant going under?
Objection, Your Honor, lack of foundation. May I be heard?
You may.
Opposing counsel has not established that a high school student was used to develop this website, and I ask they lay that foundation before continuing with this line of questioning.
Objection sustained.
Mr. Fitzpatrick, you had a high school student build you a website during the middle of the pandemic, correct?
Yes, when those subscription services were too expensive for us, we tried to use our resources best we could to make a shot at this online ordering. And so a high school student was an affordable option.
Once again, I would like you to confine your answers to yes or no, please. And this website didn't work out very well, did it?
No.
So you don't blame this high school student for your restaurant going under, since presumably if that website had worked, you might have done better.
I don't blame them. I believe that we took a chance to try to adapt to the pandemic, and we didn't have enough room to properly adapt due to these restrictions. I don't blame them. I blame the restrictions.
Well, speaking of you adapting, you never tried to use the back alley behind your restaurant for outdoor seating, correct?
No, I mean, there was a narrow alleyway. There were two gigantic dumpsters in that alleyway. There was no way to seat my customers. And the other side of my restaurant is a sidewalk.
But given your love for DIY projects, you never even thought of trying something in one of these areas if you cared so much about your restaurant to keep it afloat.
I can't build a bigger alleyway. There was nothing I could do in that situation. I arranged the restaurant as best I could using an industrial designer, an optimization program, the head of a Buckeye Restaurant Association. I used all the resources I had to make sure I could put more customers in my restaurant. And I explained to you already exactly the situation I was in when I made all of those adaptations.
And one final question, yes or no? Would you say that restaurants are heavily regulated?
To a certain degree, it's mainly to do with food sanitation and technical violations of the building. In those areas, I would say yes.
Thank you. No further questions, Your Honor.
Thank you. Do you have a redirect?
Yes, Your Honor.
Please proceed. I think you're on mute.
Apologies, Your Honor.
Not a problem.
Mr. Fitzpatrick, opposing counsel talked a little bit about your profit margins in your restaurant and about you filing for bankruptcy on cross-examination. Did you make a profit after you attempted to file for bankruptcy?
I mean, yes, we managed to pull through that time, and in the following decade, we got enough, our profit margins high enough that we could start investing back into our restaurant.
Were those profits that you're speaking of between the 3 to 5% standard profit margin?
Yes.
Opposing counsel also addressed some of your PPL that you took in 2 PPLs. How did you use this PPL money?
Well, we used it to keep our restaurant going during the pandemic. Like I said, it was a slow start to the year, as it is every year in the winter. Our restaurant was shut down right before our usual pickup on St. Patrick's Day, and so we used those PPL loans to pay our expenses that we would usually make up for later during that rush of the season.
Was that PPL money used to help finance that website you tried to make?
Yes, it was.
Were the takeout services like door delivery or Ultra Eats financially possible for your restaurant?
No, it was with the having just invested into our restaurant, having us being the inopportune time of the year, we weren't able to invest in those, and I was very envious of the restaurants who had that infrastructure in place.
Now, opposing counsel also talked to you about using your back alley for outdoor seating. And you mentioned that there were 2 dumpsters in that back alley. Do you own those dumpsters?
No, I can't tell you who does.
Are they communal dumpsters?
No.
Or excuse me, Mr. Fitzpatrick, do the different businesses around the alley use those dumpsters?
Oh, yes.
Thank you, Your Honor. No further questions.
Thank you, Counselor. Have you got a recross?
Yes, briefly, Your Honor.
Okay.
Mr. Fitzpatrick, when your business was struggling, the government gave you $250,000 of PPL loans, correct?
That is correct. I applied for those loans.
So yes or no, you would agree that when you were in need, the government provided you with money when you couldn't get it anywhere else?
I would agree with you that they provided with me those loans. I would not agree that that was assisting my restaurant in any way. As you can see, it closed down anyway, and it was attempting to fix a problem that the government itself has caused.
So to be clear, you think that $250,000 loan did not help your restaurant at all?
Maybe it helped it continue on for a little longer, but it certainly didn't keep it alive.
Thank you, Your Honor. No further questions.
Thank you. The witness is excused. Have you another witness to call?
Yes, Your Honor.
Please proceed.
The relator calls Phoenix Anderson to the stand. Good afternoon, Mr. Anderson. My name is Eliza Sullivan, and I will be asking you some questions on behalf of the relator today.
Good afternoon.
Please state your name, spelling the last for the record.
Phoenix Anderson, Anderson.
Are you employed?
I am a certified public accountant, or CPA, and I run my own CPA business, Anderson Accounting.
And do you have any education in this field?
Well, I actually initially went to college on a tennis scholarship, but I'm no Roger Federer or anything. So I ended up switching to a more practical area of study, and I graduated in 2002 with a Bachelor's of Science in Financial Management. Additionally, I got my CPA license in 2007.
And do you have any experience working in this field?
I do. After I graduated, I actually moved to New York, which was an amazing experience for me. I worked for Fountainhead Fund there for some time. Eventually that did get old, and I decided to move back here to Harmony, where the rent's a little cheaper. And I worked at Rand and Associates before finally hanging up my own shingle and starting my own independent operation.
And did you work for anybody as an independent CPA?
Yes, I worked for the restaurant Fitzpatrick's for over a decade.
Your Honors, pursuant to Rule 702, the relator asks the court to recognize Phoenix Anderson as an expert in financial management and accounting due to his education and experience in the field.
Any objections?
Yes, Your Honor. Under Rule 702, Part 2, a witness may only be qualified as an expert if they can offer reliable evidence. Mr. Anderson has a personal connection with the Fitzpatrick's family, isn't actually married to Mr. Fitzpatrick's cousin and therefore cannot offer reliable information.
Do you have a response?
Yes, I do. I believe 702B specifically refers to scientifically accurate testimony, and bias does not affect that. In addition, Mr. Anderson was working at Fitzpatrick's prior to marrying Hollis's cousin. So he can give, so he was already a part of the Fitzpatrick's family, so to speak, the business family, and joining Fitzpatrick's family through marriage really had no impact on his credibility as an.
Objection overruled. We'll admit this expert is a witness.
Mr. Anderson, Mr. Anderson, I'd like to talk about your experience with the former establishment Fitzpatrick's.
Of course.
So what was your role working for Fitzpatrick's?
I was initially hired as the numbers guy. I was hired as the financial advisor for Hollis, although I did switch to full-time financial manager in 2008.
And why did you make this switch?
The Great Recession was going on, and Hollis's restaurant, just like everyone else, was struggling at the time. So I offered to become more involved.
And how long did you hold that position for?
I held that position until the restaurant's closure in 2020.
Now, you mentioned that you worked at the.
Yes, it did. And that just proved that Hollis's business model was
And
able to survive
after
something as
the,
severe as a recession.
Business survived the recession. What was
So
Fitzpatrick's
around
financial
2012, our
situation?
finances started to pick up again. And that profit kept increasing each year around by 2% until 2019, with an average of 3.5% overall profits over the course of those years. So it's pretty good. And because of that, I actually recommended to Hollis that he make some investments into the restaurant.
And what were those investments?
We actually invested in a lot of things. He took out a $23,000 loan. He got 2 pinball machines. My personal favorite was the Avengers machine. It has a lot of really bright lights. It's pretty cool. We got an ice cream bar. We got to the point of sale system, which is what our customers record their orders with, or what our service record the customers' orders with. And we got a 4K screen projector, which was primarily used for local sports games, which, you know, if a tennis tournament was on, I might turn that on, or Hollis might turn on some PBS show that he enjoys.
And did these installments work well for the restaurant?
Very initially, we did see an increase in customer attendance, but all of that was dashed away starting March 15th when executive orders shut down all in-person dining.
And how long were you shut down for?
We were shut down for 2 months, and it was just the worst timing possible for the restaurant.
Why is that?
So typically Fitzpatrick's experienced a slow period from January to February, right? And we actually have a small cash reserve prepared in anticipation for that. But, you know, in March, there's St. Patrick's Day, and we do usually see an increase in business at that time, an uptick. And because we were closed before that point, we just couldn't make money, right? So when we opened up with restrictions 2 months later, we were already in the hole.
You mentioned restrictions. Would you recognize a copy of those if they were shown to you?
I believe I would.
Let the record reflect that I am screen sharing a clean and unmarked copy of what has previously been entered into evidence as Exhibit C, Buckeye Governor's Orders Reopening Restaurants, Parts 1 and 2. Opposing counsel, is this clean and unmarked?
Yes.
And Mr. Anderson, can you explain how some of these restrictions may have affected Fitzpatrick's?
Yes, I can. First off, if you look at
Objection, Your Honor.
Yes, proceed.
A lack of personal knowledge. May I be heard?
Yes.
Mr. Anderson was not there for when these restrictions were created, and is actually accountant for Fitzpatrick, so he doesn't have any personal knowledge regarding these restrictions, and therefore should not be able to testify on such.
May I respond?
Yes, you may.
Given that we are showing Mr. Anderson the exhibit currently, he can see the restrictions that were mandated. And given that he was the accountant for Fitzpatrick's, he can speak to what the financial looked like during this time when the restrictions were in place. So he can reasonably extrapolate, you know, he can reasonably extrapolate that these may have had a specific effect on the business.
May I respond?
Objection overruled.
Thank you.
Would you like me to re-ask the question?
yes, please.
So can you explain how some of these restrictions may have impacted the restaurant?
Yes, I can. There are a few really important ones here. First, you can see that businesses must reduce capacity to 50% of the normal capacity limit, including staff and customers. In addition, in line 3A, we have to ensure a minimum of 6 feet between individual parties when waiting and dining. And those combined actually resulted in a 53% reduction in our capacity over the 50% with the other restriction. And that was just terrible for the restaurant.
I'd like to direct your attention to line 2A on part 1 of the exhibit. Here, the health department mandates that in-person dining be closed no later than 6 p.m. Can you explain how this affected the restaurant?
Of course. So the Fitzpatrick's restaurant had peak hours from 5 to 8 p.m. And that's where we actually derived 60% of our profits. And because we were forced to close in-person dining at 6 p.m., 2 out of our 3 most important hours were effectively reduced by 100%. And that was the final nail in the coffin for Fitzpatrick's. With that, we were just losing money.
And did you try to work around any of these restrictions in any way?
We actually did. For example, Hollis did try to set up a website to maybe increase more carryout orders. But I mean, even if we were able to establish something like that and make it really popular, we would have to increase the amount of parking spots for increased customer traffic. We'd have to create a waiting area in the restaurant. And all of that was too cost prohibitive. And it was too much for the payment protection loans that Hollis took out.
And what did you use these payment protection loans for?
I mean, we use them for everything to keep the restaurant open. First off, we use them for food and things like keeping staff on payroll.
And was it enough money?
It unfortunately was not.
Why not?
Over the course of when we were initially shut down to when we closed, we were losing an average of $730 a day. And because of that, we just couldn't make a profit, right? And with all of these restrictions in place, we were not able to keep the restaurant open because when we were shut down for those first 2 months, I mean, we were making nothing essentially, right? Only call orders. And we accrued a deficit from that. In the first PPL, part of that was used to pay off the deficit. Then we ran out of that PPL. The second PPL was used for the same exact purpose. And at the end, by the time when we closed in December, I mean, we had low funds and we had lost our loyal customer base due to all the restrictions, and we couldn't stay open. The business was not viable anymore. Because of the restrictions, we were forced to close.
Thank you. No further questions, Your Honor.
Thank you. Are you ready to cross?
Yes, Your Honor. May I proceed?
Yes, you may.
Good afternoon, Mr. Anderson. I'm going to ask you a few questions. Can you please answer them with a yes or no?
Sure, yes.
So Fitzpatrick's is and has historically been a family-owned business, right?
That is correct.
Am I correct in saying that you are a part of Fitzpatrick's family?
I mean, I started being part of the Fitzpatrick's family when I was initially hired. So yeah.
But you are also married to Hollis Fitzpatrick's cousin, correct?
Oh, yeah, we met and we dated for a while and I actually really liked them. So we ended up getting married.
So you have a close connection between your personal and professional lives.
I mean, I initially thought that it might be a problem, but really the only thing that it did was allow me to visit the restaurant more and interact with like the actual scene of the restaurant even more frequently.
But that is a yes. You did have a close connection between your personal and professional lives.
I mean, Hollis was my cousin-in-law.
Objection.
Please proceed.
This line of questioning is substantially more prejudicial than it is probative. We have already addressed that Mr. Anderson was indeed married to Hollis Fitzpatrick's cousin, but that does not affect his worth as an accountant. That does not affect his testimony here today. And whether or not his personal and professional lives were close does not have any bearing on his reliability or his competence. So it is substantially more prejudicial than it is probative.
Any response?
Yes, Your Honor. In today's trial, Mr. Anderson has been qualified as an expert and made it for expert opinion. However, under Rule 616, bias of a witness may be explored on cross, especially if it goes to the credible nature of the witness.
Objection overruled.
Mr. Anderson, I'm going to ask you that question one more time. If you can please answer the yes or no. You have a close connection between your personal and professional lives?
I mean, I work as a financial manager, or I did, and I interpreted numbers. I don't think that was affected by that, but I do know Hollis very well.
Do you recall saying Hollis didn't have any interest in leveraging financial independence?
That's true.
You admitted that Hollis had no knowledge as to what was happening financially regarding his restaurant, correct?
I mean, obviously he would know if there was slow business, if not a lot of people were coming to the restaurant, he was there all the time. But as to the actual specific values from the accounts that I was in charge of recording and understanding, he didn't necessarily know those specific values, no.
So let's talk about Fitzpatrick's before the pandemic.
Sure.
They received a high interest small business loan, correct?
That is true.
But the restaurant needed repairs from basic plumbing and old interior design.
Yeah, the 80s decorations were not very appealing.
So Fitzpatrick used the small business loan to make general repairs on the deteriorating restaurant.
I mean, some things needed repairing, and that's what he did.
Furthermore, Hollis was adamant about not updating his point of sale system to allow for electronic customer checks, correct?
I mean, we eventually did actually update that point of sale system in 2019. So I'm not sure.
I'm talking about
if that's initially, yeah, but he did come around.
The industry about 35% for the pandemic,
that's true.
just under $57 a day.
For Hollis personally, yes.
And it is true that Fitzpatrick.
I mean,
has not
obviously,
always
as I
been
mentioned
profitable,
before, the
correct?
Great Recession was we bounced back from that.
And specifically in 2020.
Yeah, and that didn't work out, but if anything, it just proved that our business
And this
model was able to
bankruptcy
survive
only fell
without
through because a
assistance.
lawyer, a family friend, failed to file some paperwork on time.
I mean, I didn't think it was necessarily important for the business to survive.
Hey, hold a second. It looks like the attorneys, I can see you raising your hand, but I can't hear anything. Are you on mute?
Yes.
Opposing counsel?
I've been saying things, but maybe I'm being like talked over by Zoom. I don't know. But yes, I do have an objection.
Okay, let's go back to where the objection was, if possible. Can you remind me the question you're objecting to and state your objection, please?
The question was about the Chapter 11 bankruptcy. And my objection is that it is more prejudicial than probative because when a layperson thinks of bankruptcy, they think of a total liquidation of assets and a financial failure, when indeed Chapter 11 bankruptcy is simply a reorganization of funds, so that could serve to prejudice the court. And in addition, this did happen 10 years ago and Fitzpatrick's is still operating today, so it really has no bearing on the financial situation of the restaurant, so it's not very probative.
Thank you, and I'm sorry for the delay in hearing that objection. Opposing counsel, do you have a response?
Yes, Your Honor. This question was not more prejudiced than probative because the previous state of Fitzpatrick's restaurant gives insight into how the business was doing pre-pandemic, which has a very real effect on how the business would do during the pandemic as well.
May I respond?
You may.
This is not immediately prior to the pandemic. This is 10 years before the pandemic, and there are an entire 10 years of financials there that if Mr. Anderson were asked about, he could speak to, and they would show the financial situation of Fitzpatrick's going into the pandemic far better than bankruptcy filed ago.
May I respond?
One more response, yep.
Your Honor, the way that the finances were held in 2010 gives information into the way the business was run, which is continuous throughout the years as well. So this actually does give information to the state of how the business was run before the pandemic as well.
Objection overruled. Sorry again about the technical glitches. So if you have an objection, I'll try and keep my eyes on you, but yeah, just keep shouting it until we hear you if that's a Zoom problem. Go ahead, Counselor.
Thank you. Mr. Anderson, in your direct, you gave numbers of Fitzpatrick's growing profit margins leading up to the pandemic, correct?
Each year was around an increase around 2%, yes.
And these numbers were generated from a cash-based accounting system, correct?
That's true.
And this type of accounting does not meet the GAAP standards, also known as generally accepted accounting principles, correct?
I mean, generally accepted accounting principles are really only used for large businesses like McArcher's and stuff. And a small restaurant like Fitzpatrick's, that would be like using a tennis racket to hit a ping pong ball, right? Sure, it works, but it's not efficient in any way.
Now, moving on to how you and Fitzpatrick chose to run the business. During the pandemic, Hollis was given a PPL funding of $250,000, correct?
Over the course of the months, yes.
And this funding was to pay employees so you wouldn't have to lay any off.
That was one of the primary functions. Obviously, it's called payment protection, but it was used for other things like food and stuff, food inventory.
And it has to be repaid as a loan if Fitzpatrick did lay off any employees. That was one of the conditions, correct?
Unfortunately, we were forced to do that because of the issue of cash flow. And yes, but that is true. We did have to assume that debt.
So the question was, according to the conditions of the loan loan had to be repaid if Fitzpatrick laid off any
Yes.
employees, yes or no? And Fitzpatrick
I
did
mean,
lay
it
off
was
almost
either
all
continue
non-family
paying
employees,
unnecessary
right?
workers or stop paying
So
food, stop paying for
sorry.
food. And
So
obviously, we
Fitzpatrick
had to keep
violated the
buying.
terms of these grants.
We were forced to because of all the restrictions imposed upon us.
So that money clearly did not go where it was supposed to. Did this funding go towards adapting for door delivery
I
and Ultra
mean,
Eats?
initially we did try to hire a high school kid to start a website to maybe increase carryout. But if we'd gone and really committed to that, as I explained in my direct, it would have been even too much even for those PPLs because we'd actually have to expand the size of the restaurant to accommodate for that.
So the question was, did this funding go towards adapting for door delivery or Ultra Eats? Yes or no?
Specifically door delivery or Ultra Eats? No.
And Fitzpatrick spent a total of $13,000 on pinball machines, correct?
That's true with that $23,000 loan.
Now, regarding the customer satisfaction of the restaurant, I want to preface this line of questioning by asking you, customers who don't feel safe will not come to a restaurant, correct?
I
Object
mean,
speculation.
Please explain.
Question is asking Mr. Anderson to speculate as to the feelings of potential customers and their reasonings behind not visiting a specific restaurant, which it's unfair to ask him to speculate as to those things.
May I
Have you have a
respond?
response?
Yes, Your Honor. I am not asking Mr. Anderson to speculate on any on the feelings of other restaurants. I'm asking him his own personal opinions of if people will feel safe coming to a restaurant or not.
Objection sustained.
Mr. Anderson, after the pandemic hit, an employee of Fitzpatrick tested positive for COVID-19, correct?
I mean, when that happens, I mean, we have to shut down the entire restaurant. And then when that does happen, it is very unfortunate. Yeah.
And it did happen, correct?
I believe so.
Fitzpatrick's continued to refuse to invest in new safer technologies like touchless pay, correct?
I mean, we would have to update the point of sale system, which we just did, and we didn't have the necessary funds to do so.
Touchless pay would have kept customers and employees safer from spreading the virus, correct?
Unfortunately, we couldn't get touchless pay, but presumably if we were able to do it, yes.
And customers will not want to enter a restaurant if it's not safe, correct?
I mean, I can't really speak to individual customers. They have their own motives and their own beliefs. But I mean, if there was like a giant bomb in a restaurant, I might not go in there personally.
And in your witness statement, you said the good governor was making what they thought was the right decision for the citizens, correct?
That's what he thought. I mean, but ultimately, I mean, there's the question of where do independent decisions come into
So
play?
in your witness statement, which was under oath, the good government, you did say that.
What they thought was the right decision.
No further questions, Your Honor.
Thank you, Counselor. Do you have a redirect?
Yes, Your Honors, we do.
Please proceed.
Mr. Anderson, generally accepted accounting principles, are they a law?
No, they're absolutely not. They're just a recommendation.
And how does cash-based accounting work?
Well, essentially, it's much different from like an accrual-based accounting system. It only records when you receive and have to pay expenses. And it's much simpler for me to record, and it was just made the entire running of the restaurant much smoother.
And in your expert opinion, is it a reliable way to keep track of finances?
It absolutely is.
Thank you. No further questions, Your Honor.
Thank you very much. Have you got a recross, Counselor?
Yes, briefly, Your Honor. Mr. Anderson, you just said in your expert opinion, it is a reliable way to keep record of finances. Once again, this type of accounting does not meet generally accepted accounting principles. Yes or no?
To answer that question, no, but it doesn't need to if it's not a giant restaurant looking for outside investment.
No further question, Your Honor.
Thank you. The witness is excused.
Thank you, Your Honor.
Respondent, are you ready with your witnesses?
Yes, Your Honor. The respondent calls Dr. Ellis Mazakis to the stand. May I proceed?
You may.
Can you please introduce yourself for the court?
Yes, my name is Els Mazkis.
Dr. Mazakis, what do you do for a living?
I am the Buckeye Director of Health and Human Services.
And what does your job entail?
Well, as director, my primary responsibilities, policies affecting all industries. enforce the mission of the department, and work with other team members
And
throughout the
Dr. Mazakis,
process.
how long have you been serving in your current occupation?
I've been serving in this position for 7 years, but I've been working at the Department of Health and Human Services for around 20.
And what did you do before your role as director?
I was a public health sanitarian before becoming director after I graduated school from 1994.
What kind of education have you received for your occupation?
Well, prior to working for the department, I obtained my bachelor's degree in health services from the University of Arizona in 1994. I then obtained my master's from the Buckeye State University in 2000 and an MD with the emphasis on epidemiology in 2004.
Your Honor, I respectfully move under Rule 702 to qualify Dr. Ellis Mazakis as an expert in public health, epidemiology, and health services.
Any objection?
Just one, Your Honor. I would like to ask that Dr. Mazakis's expertise be limited to public health in the state of Buckeye, given that that is where all of their experience and would be from.
Any response?
Yes, Your Honor. Dr. Mazakis received their training from the University of Arizona, firstly. Second of all, training is it's the same, consistent for an MD as well as an epidemiology is consistent throughout all teaching. So they should not be limited only to the state of Buckeye.
Objection overruled. We'll admit this witness as an expert.
Dr. Mazakis, what is the department's mission?
Well, the department's mission is to enhance and protect the well-being of all citizens of Buckeye by providing effective health and human services and fostering advances in medicine, public health, and services. We basically try to make decisions in the public's best interest.
And in compliance with that mission, what does the Department of Health and Human Services do?
The department's responsibilities include drafting policy and other restrictions related to health and safety of the public in Buckeye. This includes responding to emergency health situations, such as a breakout of a global pandemic.
And does this policy apply to restaurants?
Oh, yes. One of the department's main responsibilities is to oversee health regulations of restaurants and ensure that restaurants abide by the proper provisions and safety standards. In fact, these regulations are updated every 4 years to continuously reflect the latest scientific understanding of foodborne illnesses and provide the best industry practices for keeping restaurant goers safe.
Dr. Mazakis, you previously mentioned that the department responds to public health emergencies. How did the department respond to the COVID pandemic?
Well, based on guidance from the department, Governor DeBeard issued a stay-at-home order with the exception of essential workers and businesses. This meant that places like bars, restaurants, salons, and barbershops all had to close.
And what were the reasons for these regulations?
It was due to the highly contagious nature of COVID-19. At the time we implemented these precautions, our understanding of the virus was that it easily spread between individuals as a result of proximity and touch.
And what did that mean for restaurants?
Many restaurants sat individuals from various households in close proximity to each other. Restaurants were deemed as hotspots for the disease to spread and infect more of the public because individuals brought items close to their mouths and noses, making it much more likely that an individual could contract or spread the disease in a restaurant setting.
Did these regulations ever change?
Yes, we changed these regulations as our understanding of COVID-19 grew. We always made sure that we enacted regulations based on public health and safety. These restrictions were totally reasonable considering our knowledge of the virus at the time they were implemented.
And what were the new regulations?
Well, in May 2020, restaurants were permitted to outdoor dining, and a week later, restaurants could open to indoor dining if they followed certain new guidelines.
Can you talk a little bit on these guidelines?
These restrictions for reopening restaurants included that every other table must remain empty with at least 6 feet of clearance between all tables. The total number of occupants must be reduced to 50% of the normal capacity. Plexiglass must be installed between all tables and the counter. The restaurant must close to in-person dining by 6 p.m. and all customers and staffs must wear masks. COVID-19, while allowing restaurants to reopen and continue.
And how did you decide on these reopening regulations?
Myself and the rest of my team at the department worked with local restaurant owners to determine what regulations would be the least burdensome on restaurant operations, but still protect public health. When making these decisions, public health and safety was the top priority.
How did you help restaurants comply with the new regulations?
The department issued a memo, which included recommendations to comply with the regulations, such as locations to obtain plexiglass, how to develop a virtual menu, and ways to maximize seating in small arrangements.
Was there ever any negative feedback from these regulations?
Yes, apparently the ethics committee at the department received an anonymous tip that I was allowing health inspectors to take bribes from restaurant owners and look the other way regarding some of their health code violations. And my immediate impression after I heard this news was that someone was trying to play the blame game. But I can assure you that I would never allow such a thing to happen. I pride myself on holding the department, its members, and myself to the
Excuse
highest
me?
ethical and
I can
safety
see there's an
standards to
objection.
ensure.
Is that,
Yes.
sorry. Okay, sorry to be the one to interrupt and yeah, but I couldn't hear you. I could just see you. Please proceed.
So this is actually improper character evidence pursuant to Rule 608 of evidence. Defense on a person's character evidence is not allowed until their character is attacked. So Dr. Mazakis saying providing truthfulness of her character is not admissible until her character is attacked.
Have you a response, counselor?
Yes, Your Honor. Dr. Mazakis was simply elaborating on the investigation and how it proceeded.
Objection overruled. I'll allow it.
Dr. Mazakis, did you ever implement an exemption process?
Yes, although initially the uncertainty of COVID gave us little room to have an feasible exemption process in place. However, after understanding of the disease grew, we were able to evaluate each circumstance case by case.
And what did that process look like?
Exemptions were only granted to businesses that could prove safe operation without the restrictions. On November 2nd, we put a system in place and we immediately received a huge influx of applications. So much so we were processing these applications around the clock.
Are you aware that Fitzpatrick's applied for an exemption?
Yes, I am.
And what happened with that application?
Well, we notified him that we needed more information before we can make a final decision, but we never heard back from him.
Dr. Mazakis, let's transition to talking about Mr. Fitzpatrick's restaurant. Your Honor, I would now like to present what has been previously admitted as Exhibit A. May I proceed?
You may.
Dr. Mazakis, can you see the exhibit?
Yes.
Let the record reflect that I am showing a clean and unmarked copy of parts 1 and 2 of Exhibit A.
I'm not seeing the exhibit, counselor. I'm just seeing the started screen sharing notice. Does everyone else see the exhibit who needs to see
I
it?
can't see it, Your Honor.
Your Honor, I can retry sharing it.
Better.
No, sorry, that was a different part of that was a different exhibit. That's still the wrong document. I don't know why it's doing that.
If it would be helpful, I could screen share this exhibit for them because I do have it up.
Is
there.
it fine now?
Is it Exhibit A we're looking at? I'm looking at Exhibit A. That looks
Yes,
good.
Your Honor.
Thank you, counselor.
Sorry about that.
Let the record reflect that we're sharing a clean and unmarked copy of parts 1 and 2 of Exhibit A. Dr. Mazakis, can you please
These are a
identify
list of
Exhibit A
Fitzpatrick.
right on that?
Objection, Your Honor. More prejudicial than
May.
probative. May I be heard? Discussion substantially prejudiced the court against Fitzpatrick's and his business more than its probative value speaks to any regulatory environment. If opposing counsel wishes to ask Dr. Mazakis about regulations pre-pandemic, they can do so without testifying to any restaurant's health code violations because with Dr. Mazakis being certified as an expert, they are allowed to speak to hypotheticals and their department was in charge of drafting the health code. So they do have knowledge of this.
Any response, counselor?
Yes, Your Honor. First of all, this is not a question of if these regulations may or may not, these regulations existed. These did exist, and Dr. Mazakis is an expert on understanding and unpacking these regulations. And through their expertise, they will be able to testify on the state of and how Fitzpatrick's restaurant operated pre-pandemic, and especially to the safety and health, in terms of the safety and health aspect of it.
Objection overruled. I'll allow it.
Dr. Mazakis, I'll re-ask the question. Turning your attention to part 1, would you be able to elaborate on that, please?
Well, Fitzpatrick's had numerous health problems throughout the restaurant. In this case, Fitzpatrick's received a willful violation, defined as a violation where the employer purposely disregarded safety.
And now turning your attention to part 2, can you explain these health code violations?
Sure. Well, we normally have 56 points of inspection for a restaurant, and Fitzpatrick's violated many of those points due to issue like plumbing, electrical wiring, and multiple hazardous locations in the restaurant. We give A ratings to businesses that are clean, up to code, and free of violation, B to those that have some issues that must be fixed, and C ratings to businesses that are deemed as public risk and at the verge of closing. In January 2020, we had to give Fitzpatrick's a B- rating for their sanitation.
Dr. Mazakis, in your expert opinion, what do you make of Fitzpatrick's rating?
As an expert who deals with health code violations, this is very concerning to see, especially given the fact these were willful health violations and given that we are living in a worldwide pandemic.
Dr. Mazakis, let's take a moment to step back and summarize what we talked about today. In your expert opinion, do you think epidemiological events?
No, not at all at the time. I'm going to take a dice roll on the effects of this virus.
And in your expert opinion, do you think that these regulations were necessary?
Yes. In fact, with my experience in epidemiology, without these restrictions, the pathogen as virulent as COVID-19 may have taken an even greater toll on people's lives and livelihoods.
No further questions, Your Honor.
Thank you, Counselor. Are you ready to cross?
Yes, I am, Your Honor.
Please proceed.
Good afternoon, Dr. Mazakis. My name is Eliza Sullivan, and I will be asking you some questions on behalf of the relator today. So you mentioned that Fitzpatrick's got a B- rating on their health code inspection, correct?
That is correct.
But to be clear, they were allowed to stay open with that rating, right?
Well, B- is not optimal. A B- rating is very close on the verge of closure. It's like,
Stay open, correct?
I'm sorry, what was that?
They were allowed to stay open, correct?
Yes, they were not optimal.
And it's
but
true
yes, they
that
were.
the health department allowed even restaurants with C ratings to remain open, correct?
That is correct.
Even though, as they said, these restaurants can pose some public risk, correct?
Well, a B- rating or C is not optimal at all. It's like getting a D on your test. It's passing, but is that what you want? No.
So that was not my question. My question was, the health department did state that a rating of C on a restaurant means that the restaurant can pose some risk to the public health, correct?
C ratings means that they are at the verge of closure.
Objection, Your Honor. Relevance.
Go ahead.
Whether or not a worm infestation happened in this case is not relevant to the to determining if this was a partial regulatory taking in this case.
May I respond?
You may.
So relevance is a relatively low bar objection pertinent to the case, given that we're common of the restaurant industry prior to the
May I
COVID
respond?
pandemic.
You
So
may.
it is very.
Your Honor, no, under Rule 401, this line of questioning, there's no tendency to back. Once again, there was a vermin infestation does not make any action as a consequence of determination in this trial more or less probable, and
May I
therefore it's
respond?
irrelevant and should
I'll
be
give you the
excluded.
final word. Yes.
So this is actually very relevant to the final decision, given that it is speaking to the regulatory environment of the restaurant industry prior to the pandemic. And that is a very important factor in the Penn Central test, and it is a very important factor for determining what the effects of the regulations were on restaurants.
Objection overruled. I'll allow it.
Would you like me to re-ask the question?
Yes, please.
So one of the most common health code violations is a vermin infestation, correct?
Yes.
And another common one is unsanitary food handling.
Yes.
And you'd agree that both of these violations have the potential to cause an illness, correct?
That is correct. They're both very concerning to see. Yes.
So prior to the pandemic, the health department allowed for some degree of public risk in restaurants, given that they allowed restaurants to operate with health code violations, correct?
I'm sorry, could you please repeat that question?
Yes, so the government allowed for some degree of risk to the public health in restaurants, given that they did allow restaurants to operate while they had health code violations, correct?
We made sure that restaurants could abide to regulations, and allowing this was that, and so yes.
Now, I'd like to talk about how the health department handled the global COVID-19 pandemic. It's true that restaurants were closed down to in-person dining on March 15th, correct?
Yes,
And they were closed down for 2 months, right?
that is correct.
They reopened on May 21st,
Yes,
and they reopened with some restrictions, correct?
that is correct.
And you would recognize a copy of these restrictions if they were shown to you?
Yes,
Let the record reflect that I am screen sharing a clean and unmarked copy of what has previously been entered into evidence as Exhibit C, Parts 1 and 2. Opposing counsel, is this clean and unmarked?
Yes,
And Dr. Mazakis, you recognize this as the Buckeye Governor's Orders reopening restaurants, correct?
yes,
And it is clean and unmarked.
yes,
So I'd like to direct your attention to line 4A. The government of Buckeye regulated that the government of Buckeye required that restaurants reduce their occupancy to 50% of staff and customers, correct?
yes, that is correct.
And on line 3A, they established that restaurants must ensure a minimum of 6 feet of distance between parties when waiting and dining, correct?
That is correct.
And on line 4D, they established that there also must be 6 feet of clearance between tables, and every other table must be left empty, correct?
That's correct.
Now, I'd like to direct your attention to line 2A. The government of Buckeye instituted a 6 p.m. curfew for in-person dining, correct?
That is correct.
But to be clear, this curfew was only for in-person dining, right?
That is correct.
And this did not affect any other public indoor space?
Well, restaurants had to close at 6 p.m. because during 6 p.m. that was normally restaurants' rush hour, and restaurants were deemed as hotspots for this virus to spread and infect others.
Mazakis,
I'm sorry, what was that?
you don't have evidence to prove that restaurants' rush hours were at 6 p.m., do you?
I would say that with the standard that 6 p.m. was normally restaurants' rush hour.
But you do not have data that you can present to the court today to prove that, right?
I do not believe so.
And I'd like to be clear with the language here. Restaurants were deemed likely hotspots, correct?
That is correct, but they are still hotspots. It was very dangerous in a restaurant setting and risky for many people to be in a restaurant setting without these regulations.
And this 6 p.m. closure did only affect restaurants and not any other public or indoor settings, correct?
That is correct, yes.
And later on August 17th, the government did institute a curfew for all public indoor settings, correct?
Yes, that is correct.
This was for 10 p.m. and not 6 p.m., right?
Yes,
And this restriction was created because despite your department's best efforts, there were still large gatherings going on in Buckeye, correct?
that is correct.
Now, Dr. Mazakis, if a restaurant's prime operating hours were from 8 a.m. to 12 noon, they would be allowed to be open during those times, correct?
Yes,
And if their prime operating hours were from noon to 3 p.m., they would be allowed to operate during those hours, correct?
yes,
But if a restaurant's prime operating hours were from 6 p.m. to 8 p.m., they would not be allowed to operate during those hours, correct?
yes. Again, it's a restaurant's rush hour where many people come to restaurants, sit in and dine.
Again, let's be clear, you do not have data to prove that it is a rush hour, correct?
I do believe, yes.
Now, I'd like to talk about how your department handled requests for exemptions from these COVID restrictions. It's true that when the initial shutdowns and restrictions began, there was no process for exemptions in place, correct?
We did not have a fixed system in place for an exemption process because it simply just wasn't safe enough. The number of COVID deaths and cases continued to rise, and our knowledge of the virus was continuously changing. So no, we did not have a system in place.
And you did put a system in place on November 2nd of 2020, correct?
Yes, that's correct.
And it often took the health department several weeks to respond to restaurants seeking an exemption, correct?
We tried our best to respond as quickly as possible, but there was an immediate huge influx of applications that we were processing them around the clock, but yes.
And once you knew that it could take several weeks to process an exemption request, you did not post this on your website, did you?
No.
And you did not make a press release, did you?
No.
So restaurants didn't know how long they were going to be waiting for an exemption to these restrictions, correct?
Well, the exemption process was fairly new, and we weren't sure on our side how long it would take to respond back to them, but yes.
So they did not know how long?
Yes, that's correct.
Thank you. No further questions, Your Honor.
Thank you, Counselor. Are you ready to redirect?
Yes, Your Honor.
Please proceed.
Dr. Mazakis, you talked, there was some talk about how you do not have enough data about the optimal hours or for different restaurants. However, when you were making the regulations, did you work with the restaurant industry?
Yes, we did.
Secondly, there was a talk about how certain regulations were put on restaurants that were not put on other industries. But are restaurant industry spaces different than other interior spaces in other locations?
Yes, that's correct.
So is it normal for there to be different regulations put in place for different industries?
Yes. So certain restaurants have larger spaces, and we allowed certain restaurants exemptions from the regulations because we specifically looked for air ventilation and airflow, which would decrease the spread of COVID-19. So some large areas, restaurants with larger spacing were.
No further questions.
Thank you, Counselor. Would you like to recross?
Yes, Your Honor. Dr. Mazakis, you would agree that breakfast restaurants are a thing in Buckeye,
Objection,
right?
Your Honor.
Please proceed.
This falls outside the scope of my redirect.
Any response?
Yes. So the opposing counsel talked about not having data to show that that restaurants' busiest hours would be at 6 p.m. And they did talk about the health department consulting with restaurant owners. And so I'm speaking to the potential for a different restaurant's hours to be prior to 6 p.m.
Objection overruled. I will allow it.
So Dr. Mazakis, you would agree that there are breakfast restaurants in Harmony, correct?
Yes.
And a restaurant that primarily serves breakfast will more likely than not have their busiest hours prior to 6 p.m., correct?
Yes.
Thank you. No further questions, Your Honor.
Thank you very much. The witness is excused. Respondent, are you ready with your second witness?
Yes, Your Honor. The respondents call Aspen Bennett to the stand. Good afternoon. Please state your name.
Good afternoon. My name is Aspen Bennett.
And what is your occupation?
I'm currently working at Harmony Bistro as a server.
And how do you know Hollis Fitzpatrick?
I worked at his restaurant, Fitzpatrick's, for around 6 years.
And what was Fitzpatrick's like?
I really loved working there. The place had a great family feel, and I loved talking to all the customers and getting to know them in my career. But really, the place is a mess.
What do you mean by that?
Well, to start, the physical space was falling apart, from things like plumbing leaks to sketchy electrical work. And as for the food, it was pretty unsanitary, so I never ate it. I was worried it would make somebody.
Excuse me, sorry to stop. Is there an objection?
Yes, Your Honor, more prejudicial than probative. May I be heard?
You may.
Aspen Bennett discussing the physical base of Fitzpatrick's and saying things like it was a mess or that it was deteriorating or even that the food was bad is substantially more prejudicial since its probative value is very low. We are not talking about what Fitzpatrick's looked like on the inside.
My screen is frozen, Counselor. Is everyone else having the same experience?
I can hear you, Your Honor, but yes, my screen for opposing counsel is.
For opposing counsel, yes. Is that Julia? Can you hear us? And do you have another connection?
Your Honor.
There we go. We got you back again. Sorry, you froze. Do you want to pick up?
Yes, Your Honor. Do you want me to restart the objection or would you like me to pick up off?
Pick up. Yeah, just go ahead and restart if you like.
Yes, Your
Go
Honor.
ahead and explain.
So Mr. Bennett discussing the physical space of Fitzpatrick's and saying things like it's a mess and the space was deteriorating, or even that the food was bad, is more prejudicial than probative since the probative value to this is very low. We are not discussing this physical space of Fitzpatrick's. We're discussing the impact of these regulations on Fitzpatrick's restaurant. And therefore, this line of questioning is substantially more prejudicial than probative.
Any response?
Yes, Your Honor. Well, the relator is claiming today that the regulations imposed by the government drove customers away and decreased Fitzpatrick's businesses and therefore caused it to go under. And if Fitzpatrick's had a bad health code rating or if the food, as the opposing counsel said, was bad, then that would be another factor driving customers away, and that would be a factor that the government is not to blame for.
May I respond?
You may.
This idea that any sort of mess with the physical space of the food not tasting good push line of logic. It's not, we have no concrete way of proving that customers were turned away because maybe they didn't even see that the space was a physical mess, or maybe they did like the food, since this is a subjective opinion to Mr. Bennett, and therefore the probative value is still low and is still substantially more
Last word,
prejudicial.
Counselor. Any response?
Just the fact that this place was a mess would, I think, reasonably would have driven customers away in the midst of a global pandemic when everyone was concerned about safety and not getting the virus, and having a low health code rating and being, as the witness said, a mess. I think there's no doubt that that would drive a certain number of customers away.
Objection overruled. I'll allow it.
Mr. Bennett, would you like me to re-ask the question?
I'm sorry?
Would you like me to re-ask the question?
Yes, thank
I had just asked, what do you mean by saying the place was a mess?
Well, to start, the physical space was just falling apart. There were things like plumbing leaks and sketchy electrical work all over the restaurant. And as for the food, it was really pretty unsanitary. I was always worried that it was going to make somebody sick, so I never ate it. But I noticed that new customers always seem to be put off by these things, and they never seem to come back.
Did you ever bring up these problems with Fitzpatrick?
Yes, I brought them up multiple times, but he told me that it couldn't be fixed because he didn't have the money.
Was this lack of money always a problem at the restaurant?
Yes. To start, he had filed for bankruptcy a few years earlier.
Objection, Your Honor.
And to add to this, the average.
May I be heard?
Yes, you may.
Mr. Bennett has no way of knowing whether or not Fitzpatrick filed for bankruptcy 10 years ago, because firstly, Mr. Bennett was not employed at Fitzpatrick's 10 years ago. And secondly, Mr. Bennett was not an accountant nor a financial expert, nor did they have access to the exact financials of Fitzpatrick's. And therefore, this is outside of the scope of their knowledge.
Any response, Counselor?
Yes, Your Honor. Mr. Bennett worked at Fitzpatrick's for a number of years. He worked at Fitzpatrick's for 6 years, I believe, and he had a personal relationship with Mr. Fitzpatrick. So although he may not be a financial expert, he is aware of the fact that Fitzpatrick did file for bankruptcy 10 years ago.
May I respond?
You may.
Just because an employee is close with their employer or that they worked there for 6 years, which again, I would like to reiterate is outside of when Mr. Fitzpatrick attempted to file for bankruptcy, does not mean that they would have knowledge of this. And if they do have a way to have knowledge, I ask that opposing counsel lay more foundation to indicate how they would have this knowledge.
Response, Your
Any
Honor.
response, Counselor?
Yes, Your Honor. I am not asking Mr. Bennett to elaborate on the existence of bankruptcy. I'm just asking, all he did was state that it existed, and I think he does have knowledge of that fact.
Objection overruled. I'll allow it.
Mr. Bennett, you were just talking about the financial situation at Fitzpatrick's.
Yes, I was. So in addition to that bankruptcy that I mentioned, the average table was barely spending $20. In addition to that, payday for me was stressful too, because Hollis seemed to always pay us late. Because of this and the DIY repairs and the bankruptcy and all this stuff that was going on with the finances, it was clear that long before the pandemic started, Fitzpatrick's was not making a lot of money.
And what was the clientele like at Fitzpatrick's?
I noticed that they were mostly an older crowd of returning customers. New customers never seemed to come in. And these old
Your Honor,
customers would always seem to hang around.
Second, yes, objection. What's the basis?
Invention of fact, Your Honor. Mr. Bennett does say in his statement that new customers did come into the restaurant occasionally.
Any response, Counselor?
Would the witness be permitted to rephrase his response?
Objection sustained. Please rephrase the question.
So what was the clientele like at Fitzpatrick's, Mr. Bennett?
They were mostly an older crowd from my view. These older customers and returning customers always seem to take up space and use the place as more of a gathering area than a place to buy things. They always spent a lot of time there while not spending a lot of money.
So what was the typical time that customers came in?
Well, the restaurant was pretty quiet by 5:30. Fitzpatrick would send many of his employees home by then, actually. But sometimes he would have me standing outside trying to drum up business from the street.
Moving on, let's talk about when the pandemic hit. So when the pandemic hit, what happened to all the restaurants in Harmony?
Excuse me. Well, many restaurants in Harmony and around the country stayed open by using methods such as walk-up windows and delivery services. I offered the idea of using these delivery services like...
Knowledge, have you heard?
You may.
Mr. Bennett has no way of knowing what systems other restaurants use to stay open during this closure. He would have no knowledge that they are using take-up windows or they're using delivery services, and therefore he cannot comment on this.
Any response, Counselor?
Yes, Your Honor. Mr. Bennett is a citizen of Buckeye and a resident of Harmony, and he has knowledge of what restaurants in his community are doing and whether they have takeout or whether they have home delivery.
May I respond?
You may.
If this is the case, I would ask that opposing counsel lay some foundation to indicate this fact.
Any response, Counselor?
No response, Your Honor.
Objection overruled. I'll allow it.
Mr. Bennett, you were talking about what happened to other restaurants in Harmony when the pandemic hit.
Yes, they were using lots of different methods like walk-up windows and online delivery services like Ultra Eats and door delivery. I actually suggested using these ideas to Hollis. It seemed like a no-brainer because I had seen them used in so many restaurants around Harmony. In fact, my current employer, the Harmony Bistro, has adapted well to these restrictions by using some of these delivery services.
And how did Mr. Fitzpatrick respond to your idea?
He dismissed the idea and instead decided to only take orders over the phone. This meant he was losing more money unnecessarily.
Did you offer to help in any other ways?
Yes. I offered to help spread word about Fitzpatrick's on my own social media accounts. And in addition to that, I offered to create and operate accounts for Fitzpatrick's for free. But again, Hollis refused.
Did you try anything else to help Mr. Fitzpatrick with this business?
Well, I really wanted to help him in any way I could. So I offered more ideas like using bag lunches that people could pick up or using the hostess stand as a makeshift no-cost takeout window. But none of these ideas or offers of free help were good enough for Hollis. He was just refusing to take any responsibility for his restaurant.
Did the pandemic regulations ever change?
Yes, they did. Governor DeBeer finally announced that restaurants could open for in-person outdoor dining. But Hollis told me that he didn't plan on opening for outdoor seating. Apparently there wasn't enough space.
But did you think there was space?
Yes, I did. I actually suggested using the alley behind the restaurant, but Hollis refused this again. I was shocked. Other restaurants were making do with what they had, using every inch of space, including parking spots. At Harmony Bistro, all we had to do was put up some string lights to make customers feel more comfortable outside. Hollis could have done something similar with his outside space, but once again, nothing was ever good enough for him.
Was Fitzpatrick's ever able to open again for an in-person dining?
Well, on May 21st, we were allowed to open for indoor dining with some restrictions, including limited capacity and an earlier closing time. This early closing time didn't really change anything for the restaurant, though, because like I had said earlier, the restaurant was dead by 5:30 anyway.
And how did Hollis adapt to these capacity restrictions?
He actually became really petty about it. He seemed to be going out of his way to show that we couldn't follow the regulations to prove some sort of point. There were other ways that we could have rearranged the tables, for instance, but
Hold on
he
a second.
instead opted.
Excuse me a second. Is there an objection?
Yes, Your Honor, to speculation.
Would you like to expound?
Yes, Your Honor. Mr. Bennett has no way of knowing that Mr. Fitzpatrick was intentionally refusing to adapt to these regulations to spite the government or any such thing. And therefore, he cannot comment on Mr. Fitzpatrick's motivations behind not, in what his eyes, he sees as not adapting to the regulations.
Any response, Counselor?
Yes, Your Honor. Mr. Bennett is merely testifying to his perception of Mr. Fitzpatrick's actions, and yeah.
May I respond?
You may.
This perception is material to today's case because it addresses the adaptability of Mr. Fitzpatrick. And since it is so material to today's case, it is weighed heavily, and this type of speculation cannot be admitted into court.
Last word, Counselor?
Yes, Your Honor. Opposing counsel just said that that Mr. Bennett's opinion is, if I heard correctly, is material to the case, in which case I don't see why it shouldn't be admitted.
Objection sustained. Could you reword the question, please, Counselor?
Yes, Your Honor. Thank you. Did Fitzpatrick's ever? Well, what happened to Fitzpatrick's later in the pandemic?
Well, later on, as things got worse and his lack of action led to more stagnation, Hollis had to lay off all non-family members. But he kept me on because I had been there the longest, and I'll always be grateful for what he did to me and how I was able to keep my job during this pandemic.
So you had a good relationship with Hollis?
Yes, I would say we were on good terms. Like I said before, he kept me employed even when he had to lay off all non-family members. And my general experience at his restaurant was great, and my experience with him. I had previously worked at a restaurant called Antonio's, which had a far worse work environment. So when I came to work at Fitzpatrick's, I was blinded by all the positives there, and I couldn't see through to all the negatives of the restaurant to see how much of a mess it truly was.
Did things ever go sour between you and Mr. Fitzpatrick?
Excuse me. Yes, he accused me of stealing. This was really a shock to me, considering I had been one of his longest employees. Personally, I thought we were pretty close and on good terms. For all my 6 years of working there, we had never had any problems. And since he had kept me employed, even when he had to fire all his other non-family members, honestly, I thought we were on good terms. In the end, his accusation for me was the last straw.
And why did you end up leaving Fitzpatrick's?
Objection, Your Honor, lack of foundation. May I be heard?
You may.
Opposing counsel has not laid foundation that Mr. Bennett did leave Fitzpatrick's, and I asked they lay that before asking why Mr. Bennett left.
Any response?
No, Your Honor. May I rephrase the question?
You may. Objection sustained.
Mr. Bennett, did you ever leave Fitzpatrick's?
Yes, I quit in September of 2020.
And why did you do that?
Well, I just had enough of what was going on with the restaurant. Hollis continued to refuse to adapt to the regulations, and business was getting worse by the day. We couldn't compete with other restaurants which actually had sane owners with senses of self-preservation. My paychecks got even smaller.
More
And tips.
probative. May I be heard?
You may.
Mr. Bennett is talking about Mr. Fitzpatrick in a very negative way that is substantially prejudicial to the court, and there is very low probative value in talking about Mr. Fitzpatrick in such a disrespectful way.
Any response, Counselor?
I don't believe Mr. Bennett said anything about Mr. Fitzpatrick in his most recent response. All he said is that other restaurants in Harmony were able. He was just talking about other restaurants in Harmony. They were able to adapt to the regulations much better than Fitzpatrick was.
May I respond?
You may.
Mr. Bennett's exact words that I'm objecting to is he said Mr. Fitzpatrick was not sane, and that is the specific part that I'm objecting to.
Response, Your Honor.
Yes.
Mr. Bennett never said that Mr. Fitzpatrick was not sane. He simply said that there were other restaurant owners in Harmony who had sane senses of self-preservation.
Objection overruled. I'll allow it.
I suppose we'll backtrack a bit. Mr. Bennett, I will re-ask the question. Why did you stop working at Fitzpatrick's?
Well, like I said, around September, I had had enough of what was going on with the restaurant. Hollis was continuing to refuse to adapt to the regulations, and business was getting worse. We couldn't compete with these other restaurants, which I mentioned. They had sane owners with senses of self-preservation. My paychecks got even smaller, and my tips began to vanish as business slowed to a crawl. So in the end, I quit.
And did you find a new job?
Well, I couldn't be out of a job during the pandemic, so I applied for and got a job at Harmony Bistro.
And what's it like there?
Excuse me. Well, it's hands down the best restaurant I've ever worked in. We use online delivery services like door delivery to keep orders coming in. And we have a takeout stand set up outside the entrance to keep capacity under control while keeping our sales up. We also set out tables in the back alley, and we put up string lights to make the customers feel more welcome. In the end, we've adapted really well to these pandemic restrictions.
I'm glad you're happy. Overall, how would you assess your experience working at Fitzpatrick's?
Well, in the end, I really loved working for Hollis, and I loved working at his restaurant. All the experiences I had there during my career, talking to people and learning more about the restaurant waiting experience in my career was really valuable to me. And when the pandemic came, I was beyond grateful that he kept me employed, and I did my best to help out in any way I could with all my free suggestions of help. Unfortunately, Hollis was stubborn to change and the restaurant closed. But restaurants aren't really the safest places. You're always in close contact with people, talking and eating. Customers still come out when they're sick, and many servers have to come to work even when they're sick too, because they can't afford to miss a day of pay. So in the end, I'm glad that we're able to keep all of our employees and customers safe with these regulations.
Thank you, Mr. Bennett. No further questions, Your Honor.
Thank you, Counselor. Are you prepared to cross?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Good afternoon, Mr. Bennett. My name is Miss Peter. I'm going to be asking you some questions on behalf of the relator. As you mentioned on direct examination, you used to work at a restaurant called Antonio's, correct?
Yes, I did.
And you pled guilty to an accusation of theft at Antonio's, correct?
Objection, Your Honor.
Yes, this would.
Yes, please
Uh,
expound.
Oh,
Yeah, there was an objection, Your Honor. Would you like me to elaborate?
Oh, sorry, there was an objection. Yeah, okay, sorry. Yes, please elaborate.
Under Rule 401, the Mr. Bennett's guilty or not guilty plea on a criminal charge a number of years ago has no bearing on this case and does not tend to make any fact material to this case more or less probable, and is therefore inadmissible under Rule 402.
May I respond?
You may.
Thank you, Your Honor. This line of questioning goes to Mr. Bennett's truthfulness or untruthfulness. If Your Honor will allow me to continue, you will see that Mr. Bennett pled guilty to this accusation of theft, and then they claim that they did not steal, and therefore by taking this plea deal, they were being dishonest. And this goes to their truthfulness or untruthfulness, which is relevant to the truthfulness or untruthfulness of their testimony today.
Any response, Counselor?
Yes, Your Honor. Under Rule 403A, this testimony is more prejudicial than probative, as it will lead to an unfair prejudice against Mr. Bennett and does not provide any real probative value to this case.
May I respond?
Yeah, I'll give you the final word, yes.
The probative value in this question, as I said before, is the truthfulness or untruthfulness of this witness. While it is slightly prejudicial, it is substantially more probative because it goes to the reliability of this witness and their testimony.
Objection overruled. I'll allow it.
Mr. Bennett, would you like me to re-ask the question?
yes,
You pled guilty to an accusation of theft at Antonio's, correct?
yes. They accused me of stealing based on a misunderstanding based on their policy of allowing waiters to take tips out of the cash register. They blatantly accused me of stealing based on nothing except this misunderstanding, and I was forced to plead guilty because my family could not afford a good attorney. The public defense attorney suggested that I clear my record by pleading guilty, so that's what I had to do just to get it off of the table and continue on with my life. So yes, technically I did plead guilty. Sorry,
You claim that you did not steal, correct?
I did not steal.
So by taking a plea deal that said you did steal when you claim you didn't steal, you were being dishonest, correct?
I would say no.
Is that an objection?
Yes, Your Honor. Lack of personal knowledge.
Would you like to expound?
Yes, Your Honor. Mr. Bennett is not a lawyer, and he is not familiar with the exact terms of what a guilty plea means, and I don't think he can answer the question about whether he was being truthful or not in his plea deal.
May I respond?
You may.
Since Mr. Bennett worked with a public defender, this public defender explained to him that by taking the plea deal, like he mentioned earlier in his testimony, it would be a lot easier on his family, a lot easier on time, a lot less money, a lot less cost to just plead guilty. And Mr. Bennett would have a rationally based knowledge that by taking this plea deal, he was saying he stole. And so therefore, this is within the witness's rational personal knowledge. They should be able to logically get here.
I'm going to overrule it.
Mr. Bennett, would you like me to re-ask the question?
Yes.
So by taking a plea deal that said you stole when you claim you didn't steal, you were being dishonest, correct?
I would say yes, technically, but dishonest in the sense that I'm simply bending to the to how I'm being charged by the government and trying to get it out of my life as a criminal charge that's false. I'm just trying to adapt to the situation I've been given and get it out of my life and continue on with my career of doing honest work. So I'm being dishonest in the very technical sense you're giving me.
So accused you of stealing, correct?
I'm sorry, can you re-ask the question?
Mr. Fitzpatrick accused you of stealing as well, correct?
Yes, it was a completely false allegation based off of nothing.
And this false allegation frustrated you, correct?
Objection, Your Honor. Relevance.
Go ahead and explain.
Whether or not Mr. Bennett was frustrated with Mr. Fitzpatrick's accusation does not tend to make any fact material to the case more or less probable.
May I respond? This line of questioning goes to Mr. Bennett's bias against Mr. Fitzpatrick, since he was frustrated with Mr. Fitzpatrick. And under Rule 616, bias is highly relevant and always relevant.
Objection overruled.
Mr. Bennett, this stealing accusation, this false stealing accusation, frustrated you, correct?
I would say it's frustrated me in the way that I'd had a large personal relationship with Fitzpatrick and we were on good terms. So the fact that he would accuse me based on nothing, a blatant, just false accusation, it did frustrate me in that way, but not in a way that I was angry at him for a long time or had bad intentions towards him, just that I felt frustrated by this change of action against me.
And Mr. Bennett, your paychecks also got smaller around the time you left Fitzpatrick's, correct?
Yes, that was a component. I needed the money to pay my rent and pay my bills. So the fact that I was losing money or getting a lack of money coming in was part of that.
Your tips also reduced around that same time, correct?
Can you re-ask the question?
Yes, your tips reduced around that same time, correct?
Yes, that was a part of having a lack of new customers and customers that use the place as the gathering area.
And you felt Mr. Fitzpatrick was using bad business practices, correct?
Yes, that was part of it. Bad business practices and lack of proper action to adjust the pandemic regulations.
And all of these things frustrated you, right?
I would say the lack of action in responding to the pandemic regulations did frustrate me in some ways.
And
yes.
Today testifying against Mr. Fitzpatrick, correct?
I'm testifying against his claim to that the pandemic regulations were the reason that his restaurant shut down instead of his own lack of action and incompetence.
Thank you. Now, you are not a financial expert, correct?
Not technically, but I worked in the restaurant industry for many years of my life.
Asked that you are not a financial expert, and that is, you are not a financial expert, correct?
I said technically no.
Fitzpatrick's exact financials,
Can you
correct?
re-ask the question?
Yes or no, you didn't have access to Fitzpatrick's exact financials, correct?
Technically no, but I was, I had a,
Correct?
I'm sorry, your audio keeps cutting out. Can you re-ask the question?
Yes or no, you were not a manager at Fitzpatrick's.
No, I was not a manager. That doesn't mean I had no idea what was going on. I worked there for 6 years as a
At Fitzpatrick's.
manager, as a waiter close.
Thank you. You were only ever an employee at Fitzpatrick's,
Yes.
correct? Fitzpatrick should institute a delivery service at his restaurant. However, you don't know if that was a financially viable option for Fitzpatrick's, do you?
Objection, Your Honor. Relevance.
Go ahead and explain.
Whether or not Mr. Bennett was aware of the financial viability of certain options has no bearing on this case.
May I respond?
You may.
Opposing counsel's argument is shaping up to be that Mr. Fitzpatrick didn't adapt during COVID. And one of the things they are using to back this up is that Mr. Fitzpatrick didn't institute a delivery option at his restaurant. By demonstrating that Mr. Bennett doesn't know if this was a viable option for Fitzpatrick's, I am demonstrating that this so-called lack of adaptability might not have been a lack of adaptability, but instead a lack of ability to institute something.
Objection overruled.
Mr. Bennett, you do not know if instituting a delivery service was a viable option for Fitzpatrick's, do you?
Can you restate the question, please?
You do not know if instituting a delivery service at Fitzpatrick's was a viable or a financially viable option, correct?
I would say no. I saw it used in so many other places around Harmony. It was such a popular option that I thought I should suggest it to Fitzpatrick as a free idea.
And you also thought Fitzpatrick should have sat customers out in his back alley, correct?
Well, the way you put it, you put it as sitting customers out in the back alley is a bad thing. I suggested he adapt to the regulations by cleaning and making his back alley more habitable for customers so that he could use it to utilize some of the space in his restaurant.
So it's your testimony today that you did not suggest he use his back alley?
No, I did suggest that he use his back alley.
And there are 2 dumpsters out in that back alley, correct?
I'm not sure. Which back alley? What part of the back alley are you referring to?
There were just 2 industry-sized dumpsters in that back alley, correct?
As there were for any restaurant, I would say yes.
And you do not know if Fitzpatrick owned those dumpsters, correct?
No, I don't think I know who owns the dumpsters near Fitzpatrick's.
And so you are suggesting that Fitzpatrick seat customers outside by 2 dumpsters, correct?
No, I'm suggesting that Fitzpatrick make the area around his restaurant more habitable for customers in any way that he can. Obviously, if there are 2 dumpsters that he can't move or own, then he shouldn't do it. But there are obviously other places. Like I said, other restaurants were using parking spots to seat tables and hanging up lights to make customers feel more welcome. There are many ways that he could have done these things that could have been more optimized, and he did not do them.
So you worked in restaurants during the flu season, correct?
Your Honor,
Can you restate?
relevance.
It's an objection. Okay, please explain.
Whether or not Mr. Bennett worked in other restaurants during the flu season has no bearing on whether or not the pandemic regulations were a partial regulatory taking.
May I respond?
You may.
Through this line of questioning, I'm going to show that businesses were not shut down or there were really no regulatory change based during the flu seasons in Mr. Bennett's experience at restaurants. And this is going to show the contrast between the regulatory environment in the past and the shocking change in regulatory environment during COVID-19. And it's going to talk about the regulatory nature of the environment, which goes to the second factor of the Penn Central test.
Objection overruled.
Mr. Bennett, you worked at restaurants during the flu season, correct?
Yes, I worked at restaurants all year round, so I assume I worked there in the flu season.
Including the swine flu season, correct?
Can you restate the question? I'm not sure what year the swine flu was.
It was in your witness statement, correct, that you worked at restaurants during the swine flu season, right?
Yes.
And during the flu season, restaurants were never shut down, correct?
No, they weren't.
Nor was a curfew implemented during the flu season, correct?
No, there was no curfew for closing time.
Nor were restaurants expected to seat customers 6 feet apart during the flu season, right?
I would say no, but all these things still correspond to a virus that's going around. There's still changes in business that happen during these during the flu season and the swine flu season.
Like there were no restriction. There was no, the government didn't mandate restaurant owners keep 6 feet apart between restaurant goers during the flu season, correct?
No, there was not that exact mandate.
Thank you, Your Honor. No further questions.
Thank you, Counselor. Opportunity to redirect.
Yes, briefly, Your Honor. Mr. Bennett, could you briefly explain why you pled guilty to the charges of stealing when you were working at Antonio's?
Excuse me. They had accused me based on a misunderstanding because they had a policy where all waiters could take their own tips out of the cash register based on what they had earned. I was simply following this guideline and this protocol they had in place, and they saw it as me taking money and stealing. So they had accused me of stealing. I had a public defender because my family couldn't afford a good attorney. The public defender simply instructed me that it would be a good idea to plead guilty in order to get this, to proceed with the punishment mandated and get the case out of my life so I can continue on with my career.
So do you steal anything from Antonio's?
No, absolutely not.
Thank you. No further questions, Your Honor.
Opportunity to recross?
I believe we are out of time, Your Honor, so no.
Thank you very much, Counselor. The witness is excused. All right. Would the parties like a 2-minute break to prepare closing statements?
Yes, Your Honor.
Oh, now everybody's completely frozen. Unless it's me.
Try again. Can you hear me, Your Honor?
I can hear you. Can you hear me? Are you good?
I can hear you.
Okay, I think we're back. All right, please proceed.
Yes, we would like a 2-minute period of time.
Thank you. I will set my timer and I will be on mute. That's my 2-minute warning. Parties, are we ready?
Yes, Your Honor.
All right, you may proceed.
Your Honors, opposing counsel, may it please the court. Constitutional protections do not pause for a pandemic. The 5th and 14th Amendments provide for just compensation when a government exercises its regulatory powers to an extent that affects the taking of private property. When a governmental action denies part of the economically viable use of property, it is a partial regulatory taking. And Your Honors, the COVID restrictions that required restaurants to reduce capacity and to close by 6 p.m. did indeed constitute a partial regulatory taking of Fitzpatrick's private property. In 1973, the Supreme Court in Penn Central v. New York provided us with a factual-based inquiry for a regulatory takings claim. We, the relator, have provided evidence to tip the balance of these facts in our favor. So let us review today's case in light of the 3 parts of the Penn Central test. First, we must look at the effect of the regulations on Fitzpatrick's investment-backed expectations. Fitzpatrick's had operated for 40 years as an in-person dining establishment. Prior to the pandemic, Fitzpatrick's had been able to seat 34 patrons, and they had been able to use their in-person dining area. In addition, prior to the pandemic, Mr. Fitzpatrick took out a $23,000 loan to make improvements on the dine-in experience. These improvements were made with the good faith that Fitzpatrick's would be able to continue operating as an in-person dining establishment during their peak hours. Hollis simply would not have made these improvements if they had known that their property would be severely restricted as an in-person dining establishment. The respondent in today's case would have this court believe that the restaurant industry is highly regulated and that the health department simply continued the previous health codes for these pandemic restrictions. But today you've heard the differences between the two. Prior to the pandemic, the health department regulated food and building safety measures, but never a restaurant's operating hours or seating arrangements. Next, we must look at the economic effects of the regulations. In Pennsylvania Cole v. Mahon, cited in Penn Central v. New York, the Supreme Court found that whether a regulatory act constitutes a partial regulatory taking depends on the extent of the reduction in the value of the property. Today, you heard both Mr. Fitzpatrick and his former accountant, Phoenix Anderson, testify that there was a significant economic impact on the restaurant, and these COVID restrictions ultimately forced Hollis to close down his business. Your Honors, in Lingle v. Chevron, the Supreme Court found that when a governmental action that does not serve any legitimate governmental objective is arbitrary and may violate the Due Process Clause. The COVID restrictions for restaurants to close down by 6 p.m. did indeed constitute a partial regulatory taking, and they were arbitrary. Because of the 6-foot distancing requirements and the 50% occupancy limit, there was no reason for the government to essentially force restaurants to close before dinner time, because with these restrictions in place, the time of day would not affect the spread of COVID-19. In addition, prior to the pandemic, Fitzpatrick's could seat 34 patrons, and their profit margins were within the industry standards. But as Mr. Anderson testified, with the COVID restrictions, their capacity was cut by a minimum of 53%, and they were losing money every day. In addition, the 6 p.m. curfew cut 2 hours a day from their most profitable time. Finally, we must look at the characteristics of the government action. Today, you heard Hollis Fitzpatrick testify that he inquired with the government about possible exemptions from the COVID restrictions, but there was no process for exemptions in place. It wasn't until 8 months after initial closures that the government had a process for exemptions. In addition, Dr. Mazakis testified that it was more often than not a 2-week waiting period for restaurants who were seeking exemptions. And in Fitzpatrick's case, the government needed more information before they could grant an exemption, adding even more time to this already burdensome waiting process. Your Honors, the burdens of the pandemic should indeed be shared by all citizens of Buckeye, but these reopening restrictions for restaurants burden small, family-owned restaurants more than others. When the government of Buckeye instituted a 6 p.m. curfew for in-person dining, they essentially assumed usage of Hollis Fitzpatrick's property for the 14 hours a week that it had been most profitable. With the already prohibitive 50% occupancy restriction in place, this curfew was simply too much, and it forced Hollis Fitzpatrick to close the doors of his Buckeye institution forever. It is for these reasons that we ask that you find in favor of the relator and initiate property appropriation proceedings. Thank you.
Thank you, Counselor. Respondent, are you ready with your closing?
Yes, Your Honor.
You may proceed.
May it please the court. Today, the relator is asking this court to issue a writ of mandamus to compel the government to initiate eminent domain proceedings against Fitzpatrick's. This court has already a few months ago dismissed the relator's total regulatory takings claim with prejudice. Penn Central, which outlines this idea of a partial regulatory taking, outlines 3 factors that courts must consider when evaluating a partial taking. First, the economic impact of the regulation on the claimant. Second, the extent to which the regulation interfered with direct investment-backed expectations. And third, the character of the governmental action. The relator has failed to meet their burden of proof, failing to show that these 3 factors weigh in favor of finding a taking. In fact, although we do not bear the burden of proof, we have shown that all 3 of these factors weigh in the government's favor. Before the pandemic, Mr. Fitzpatrick was spending recklessly, while his restaurant, which was often quite empty, was barely profitable. And after the pandemic regulations took effect, Fitzpatrick was unwilling to accept help from Mr. Bennett or make reasonable changes to keep up with the times. And the curfew did not really matter, because Fitzpatrick's was empty by 5:30 anyways, as Mr. Bennett testified. Meanwhile, Buckeye Director of Health and Human Services, Ellis Mazakis, told us about Fitzpatrick's B- health code rating. Your Honor, a business with a low health code rating and already a small customer base cannot be surprised when customers turn away in the midst of a global pandemic. And a business already on the edge cannot be surprised when they cross into the red. As we saw, when things got bad, Fitzpatrick was stubborn. Instead of doing everything to save his beloved family business, he did the opposite, refusing help when it was offered and failing to make genuine, reasonable attempts to keep his business afloat. Fitzpatrick's received $250,000 from the government in paycheck protection funds, more than 14 times their annual profit. So how can they blame the government for their business going under? And that money did not go towards keeping up with the times, and it did not go towards keeping employees on staff as it was supposed to. Instead of choosing to use that money for what it was intended, Fitzpatrick burned through that money in less than a year. Your Honor, the economic impact of these regulations was far outpaced by the self-inflicted economic impact of Fitzpatrick's own irresponsible practices. And Mr. Anderson's claims about Fitzpatrick's pre-pandemic success do not matter here, because when the time came, Mr. Fitzpatrick was stubborn and did not do what it took to save his beloved restaurant. Now for the second factor. As the Federal Circuit ruled in Roseacre Farms of the United States, food has been regulated for as long as there has been commerce. Alice Mazik has confirmed this observation for us, and in fact, Mr. Fitzpatrick admits that restaurants have always been highly regulated. As the Supreme Court ruled in Brent of the United States, reasonable investment-backed expectations are greatly reduced in a highly regulated field. And in Concrete Pipe and Products v. Construction and Laborers Pension Trust, the court ruled that a property owner operating in a highly regulated field cannot base a partial takings claim on regulations that were put in place after the purchase of the property. The case law clearly states that no matter how much money Mr. Fitzpatrick spent on pinball machines pre-pandemic, the regulations did not overly upset his investment-backed expectations. Now for the final factor, the character of the governmental action. Under Penn Central, there are three relevant sub-factors that courts must consider. First, the court must consider whether the property owner was impermissibly singled out. According to Penn Central, if a regulation applies to multiple property owners, the property owner cannot claim to have been impermissibly singled out. These regulations, of course, apply to more than one restaurant, and this subpoint clearly weighs in the government's favor. The fact that the government treated restaurants differently from other businesses has no bearing on this point. Second, courts must consider whether the regulation bears a harm-preventing purpose. Under the Federal Circuit's ruling in Roseacre Farms, the government wins this point when the purpose of the regulation is to prevent harm to public health. This was clearly the case. All parties here agree that these regulations were put in place in the middle of a deadly global pandemic. Finally, courts must consider regulatory delay. The Ohio Supreme Court ruled in State Ex Rel AWMS Water Solutions that delays of 45 months and longer are permissible. Everyone here agrees that the delays here were much less than 45 months, so this point too weighs in the government's favor. The character of the governmental action, which is instituted in the interest of public health, clearly weighs in our favor, even though these regulations may have been different from previous ones. Your Honor, the government is not responsible for irresponsible business practices, which the relator displayed here profusely. On the other hand, the government is responsible for defending public health, which it did. Fitzpatrick is trying to scapegoat the government for his business's failure, when, in reality, the government fulfilled its obligations to the people it represents, while Fitzpatrick did not fulfill his obligation to his own business. For him, it was easier to find someone else to blame than to accept the harsh reality of his own failure. Your Honor, all three Penn Central factors point towards the pandemic restrictions not being a partial taking. Respondents therefore request that this court dismiss the relator's claim with prejudice.
Thank you, Counselor. Does relator have a rebuttal?
Yes, Your Honor.
You may proceed.
Your Honors, first I would like to clarify that Fitzpatrick's claim is a partial regulatory taking and not a total regulatory taking. In addition, Fitzpatrick's tried to do the responsible thing. They tried to adapt, but they were severely limited by space and money. They tried to make a website. They tried to change their floor plan, but none of this worked. In addition, Fitzpatrick's wanted to stay open. They went into debt for it. They took out payment protection loans. And prior to the pandemic, their business was thriving. AWMS Water Solution v. Mertz requires that we look at the economy prior and during regulations. The economic situation of Fitzpatrick's prior to the pandemic was fair, and they were making a reasonable amount of profit. But during the pandemic, they were losing $730 a day. In addition, the government was irresponsible with their 6 p.m. closing time. They did not, this specific regulation did not protect public health in any way. It was completely arbitrary as per Lingle v. Chevron. In addition, they didn't communicate with restaurant owners about how long it would be to get an exemption process. And there indeed was undue delay here. AWMS Water Solution v. Mertz does state that delay can be up to 45 months, but that is for fracking industries, and the restaurant industry is substantially different than fracking industries. Finally, Fitzpatrick's did everything they could to survive, but the COVID regulations made it impossible. The government's over-regulation of their business hours was purely for the appearance of regulating, and the 6 p.m. closure did nothing. Therefore, it is a partial regulatory taking, and we ask that you find in favor of the relator and initiate property appropriation proceedings. Thank you.
Thank you, parties. Timekeepers, are there any time discrepancies the court should be aware of?
No, Your Honor.
No, Your Honor.
Thank you very much. All right, guys, we've got a 3-minute period. I'm going to ask the following questions, then I'm going to give myself a 3-minute window and turn my mute off. The question is, does either team have serious reason to believe that a material violation of any rule has occurred during this trial? I'll remain on the bench for 3 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with any student team members involved in this particular trial, but may not communicate in any way with legal advisors, teachers, or anyone outside their performing team members in this trial. 3 minutes starts now.
Your Honor, the relator does not have any post-trial objections.
Thank you.
Your Honor, neither does the respondent.
Oh, good. You saved us 3 minutes. Well done, guys. Okay, you did it. Congratulations. Does everybody want to go ahead and throw their cameras on? Judge Alecki, you've been very quiet and invisible for a very long time. I'm just going to start by saying, wow, you guys should be incredibly proud of yourselves. If I had a law firm, I would like to hire all of you. Yeah, really, really fantastic job. And I'll hand it over to Judge Alecki to give some comments.
Thank you, Patty. And thank you for staying on camera, allowing me to be off camera.
Pleasure.
Congratulations. Thank you for letting me participate in this. What a great trial. Obviously, well prepared. I think you get the case in what, September, October? We're looking at 6 months of dealing with this, and you can tell the hard work. And you can also tell if you look at the number of teams that made it down to today at state, it's not that many. So you're to be commended for that. And I think, this as a school extracurricular activity is very underrated and underappreciated. I know how much work you guys put into this. All those hours with hundreds of pages of stuff, just to whittle it down to the 1 thing, 2 things, maybe 3 things that are important is very difficult. And you guys did very well. So anything I say after this is one person's opinion, so take it for what it's worth. Yeah, I find these things to somewhat be unsatisfactory. We don't have much time. Not always sure what you guys want to hear or what we can say. So you don't get a lot of individual feedback, and it's a little bit unsatisfying, I think. And also, you're probably done and want to close your cameras. So take everything with a grain of salt, but I thought it was really good. Your witnesses on top of things, witnesses have the ability to make attorneys look good, and I thought across the board witnesses were very well prepared, and I think that's the key, is preparation. Lots of uncertainties. I'm sure if I asked you, there would be questions, things that happened that you were not prepared for, despite 6 months of dealing with it. I couldn't tell what they were, but I think preparation is really the key, that you try to think of everything, and you still can't anticipate some of the things. So, eliminating uncertainty by preparation is really the key. And as the trial went on, you could see everybody getting your legs. I hope you felt that more and more confident. The back was really good and well done. Just a couple of minor comments. The objection of more prejudicial than probative, I think that should be a relevancy objection. Again, just my opinion. That prejudicial more than probative is it's hardly ever going to be granted. To me, it seemed like that was more of a relevance objection, but a great job in explaining those types of objections. On the other side, someone on cross will you answer yes or no? I personally am not a big fan of that. Structure the question so that they have to answer yes or no, or rein them back in after they answer to say that's yes. It's hard, but those couple of just comments there that may be helpful going forward tomorrow for you. Other than that, thanks a lot. Show it to your folks and friends, and appreciate what a good job you guys did.
Thanks, Judge.
Thanks.
All right, I'm going to chime in with the same. Yeah, just so impressive. And I'm very, very aware of how challenging this is with the technology that we're dealing with. There's an awful lot of what you can do, even when you're interacting with the judge and certainly with opposing counsel, by body language and eye contact, and you're missing all of those things, which probably means there was a bit of awkwardness. There was a bit of, technology where the sound wasn't necessarily, blending together. And you guys overcame all that. So you're doing this in a tough environment and you're doing incredibly well. I agree, you guys know this case backward and forward, and it shows, and it's impressive. And you don't just know the case, you know where you want the case to go. You know how each of these arguments fits into your ultimate narrative, which is your closing argument. And you guys did a great job just keeping on track, keeping that theme going for both sides. As for objections, I love that you guys get that the objections are where this game is played. Like, nobody was the deer in the headlights. When somebody says objection, that's when you're playing at a high standard, is you're not afraid of an objection. In fact, on the contrary, objections unleash you. They give you the opportunity. I noticed one great example when there was, I believe it was a relevance objection, and in response, I was told, well, here's exactly what this witness is going to say, and here's why it satisfies element 2 of Penn Central. So, oh, okay, thank you. Like, it helps me, it helps a judge, it helps to steer exactly what you want this evidence to be used for, which you don't get an opportunity to do during examining your witnesses. So objections are just you guys did a great job of noticing that was your opportunity to argue your case, basically. So thank you for that. Don't read anything into whether your objections are overruled or sustained. I beg of you, don't think that the judge likes your case, doesn't like your case, likes your objection. This is a kind of artificial environment. All I know is that you guys are given a closed universe of information. And so if you try and say, hey, that they shouldn't be able to talk about this whole portion of information that they were given as part of this case based on an objection, my tendency is going to be to say, let them run with it. Like, yeah, we're going to let them in. We're not going to just cut somebody's arm off without me knowing how relevant that was even to your case. And that actually happens in courtrooms across the country too. Court judges are, I think, by nature curious. And it's clear what it is. So yeah, don't read anything into whether objections were sustained or not. So yeah, great job. Let's see, where was I going to go? Patient with technology, excellent. No eye contact. That makes it hard. And by the way, that makes it hard for you to wrangle your witnesses. I agree with Judge, like, I wasn't thrilled with that, just answer yes or no, please. I understood where it came from, but the problem with that statement to the witness, I'm an outside observer. All I can see is that you and this witness are wrangling with each other. You've just given him an instruction, which he's ignored. So it sort of looks like 1 point for him, as opposed to really actually helping you control that witness. So witnesses are like toddlers. Judges are like toddlers. As an attorney, you've got to be in charge of all these toddlers. It's really hard. And you guys are doing it without eye contact, without the ability to turn your back on a witness or do some sort of body language that shuts them up. So anyway, good job. And that's a challenge. It's a challenge for every attorney and everybody in this competition. There was one other thing that I would suggest that you maybe tweak for next time. The offering of his exhibits, it's this very scripted. I'm offering you a clean and unmarked copy. I'm showing this to opposing counsel, and then you go and show the judge. But when you asked of your opposing counsel, is this a clean and unmarked copy? I was suddenly aware that you were addressing a question someplace other than the court or a witness, and that didn't feel like what I expected. So maybe just tweak that introduction to exhibits. Otherwise, I'd say great job. One other thing I would maybe suggest using a little more to your advantage is if you go to the trouble of qualifying a witness as an expert, make sure you get plenty of chances to say in your expert opinion, because that's why they're there. If you qualify someone as a witness and then almost every single question or everyone is really from their personal knowledge, it's just a wasted opportunity of having qualified that expert. But that's it. You guys are doing the work of like second-year law associates in big law firms. So I hope you're tremendously proud of yourself. And as sports go, I think no sport prepares you for the real world more than mock trial. You guys are developing poise and skills and negotiating skills and presentation skills and things that are going to serve you really well. So very impressive.
Thank
That's
you.
it. Onward. Good luck in the competition.
Yeah.
Thank you.
Thank
Thank
you.
you.
You're all very
luck.
welcome. Thank you.
Yeah. Thank you. Thank you, Ben.